for the opportunity to be here today.
Well, thank you, Caitlin. We look forward to working with you. Next order of business, the introduction for RS 33065C1 having an error will not replace 647. That was a bill that I was running with manufactured homes, and because the RS had a C in front of it, we had to get a new RS, so it will not replace 647. So we'll run 647 as is and then likely send it to the amending order for the changes. Next order of business, we do have some minutes to approve. Representative Thompson.
Thank you, Mr. Chairman. I make a motion that we accept 2 sets of minutes. The first one is January 27, and the second would be for January 29th. Both Representative Birch and myself have looked over these, made any necessary changes, and they read great.
Thank you, Representative. Committee, we do have a motion to accept the minutes. All those in favor say aye.
Aye.
Any opposed? All right, we will accept the minutes. Next up, I have a couple bills to present, so I will hand the gavel over to the good vice chair.
Okay, thank you, Mr. Chairman and committee. Give the chairman just a second to walk around there. We're going to have before us first House Bill 703. So Chairman Redmond, if you'll introduce yourself for the record, we will begin the presentation.
Thank you, Mr. Chairman and committee. For the record, my name is Jordan Redmond, representing District 3 in Kootenai County. Today, I bring before you House Bill 703. House Bill 703 is focused on improving efficiency, consistency, and transparency in how DOPL regulates and serves licensees and the public. This builds on the efforts undertaken pursuant to Idaho Code cleanup last year in House Bill 14. At its core, it takes approximately 100 separate disciplinary provisions currently scattered throughout individual practice and consolidates them into a single uniform procedure that's based in Title 67. I want to be clear about what this bill does not do. It is a lengthy bill. It does not alter any board substantive practice standards or grounds for discipline. This is a procedural consolidation only, trading roughly 100 duplicative statutes into a single consistent framework. We did have a minor change that was brought by industry. We made those changes, and that's what we bring for you today is House Bill 703. So, Mr. Chairman, I would ask for to send House Bill 703 to the floor with a due pass recommendation, but I'm happy to stand for any questions.
Committee, we do have some public testimony on this bill, but do you have any questions for Chairman Redmond before we move to that point? Representative Crane? Oh, no. Okay, not yet. All right. Okay. Okay, thank you, Chairman Redmond. So first up, we'll have Mr. Sean Shupak wishes to testify on this bill. If you'll please come to the podium, introduce yourself for the record, and you'll have 2 minutes.
Good afternoon, Mr. Chairman, members of the committee. My name is Sean Shupak, and I'm here today on behalf of the nearly 800 building and highway contractors that make up the Idaho Associated General Contractors. I just wanted to testify in support of House Bill 703. As the good sponsor mentioned, there were some issues with the Practice Act in the original legislation, and we really appreciate him addressing those issues, and I'd encourage you to send this piece of legislation to the floor with a due pass recommendation. That's all I got.
Okay, thank you, Mr. Shupak. Any questions for Mr. Shupak, committee? Okay, no, thank you for your time.
Thank you.
Okay, committee, we do have House Bill 703 properly before us. Representative Crane, 12.
Thank you, Mr. Chairman. I move to send House Bill 703 to the floor with a due pass recommendation.
Okay, committee, we do have a motion before us to send House Bill 703 to the floor with a due pass recommendation. Any further questions or discussion on the motion? Okay, seeing none, we'll have a vote. All those in favor say aye. Aye. Any opposed? Okay, motion carries. Okay, next up, we'll have Chairman Redmond before us to present House Bill 704. Chairman Redmond, please introduce yourself for the record and make your presentation.
Thank you, Mr. Chairman. For the record, my name is Jordan Redmond, representing District 3 in Kootenai County. Today, I bring before the committee House Bill 704, along with my good co-sponsor, Representative Crane 12, which is Universal E-Verify for employers. E-Verify is a free web-based system operated by the U.S. Department of Homeland Security in partnership with the Social Security Administration. It allows enrolled employers to electronically verify the employment eligibility of new hires in the United States by comparing information from the employee's Form I-9 against government records. Most verifications can return results in seconds, confirming whether the individual is authorized to work. A little bit about what this bill does do. What Representative Crane and myself believe is that this actually protects Idaho's economy and workers by mandating E-Verify. It ensures fair competition by preventing unauthorized workers from undercutting wages and jobs and opportunities for Idaho citizens and legal residents. It completely aligns with federal law and national security. This bill mirrors requirements under 8 U.S.C. 1324A, promoting immigration enforcement without overreach. By verifying work authorization, it helps combat identity fraud and supports Homeland Security's efforts to track unauthorized presence. It's minimal burden for complying businesses. We all actually, the state of Idaho verifies, E-Verifies all of us. So we all have been verified through the state of Idaho. The system itself, again, it's free, and it probably takes less than a minute to actually put the data in and verify. We have about a 98.5% accuracy rate on this system as well. I think it benefits public contracts as well. It requires E-Verify for any state-funded contracts, grants, or incentives, protecting taxpayer dollars and subsidizing illegal employment. With that, Mr. Chairman, I would ask if I could have Representative Crane 12 speak a little bit about the bill as well.
Representative Crane 12, if you'd take your position at the podium, introduce yourself for the record, please.
Thank you, Mr. Chairman. Committee, for the record information, Representative Jaron Crane, District 12 in Nampa, and I'm pleased to get to do this with my good friend, Representative Redmond from District 3. So when we start talking about illegal immigration, I think it's important to take a look at how we got here. I think we were all frustrated by what happened in the previous administration on the federal level with the opening of the border. And there's estimates that go as high as 30 or 40 million people came across that border illegally. And so the question we have to ask ourselves is, where did they go? And when we look at Idaho statistics, the numbers here is that there's probably about 30,000 in the state that are undocumented. And so we have seen from Idaho voters the consistent push for us to deal with the topic of illegal immigration. And there's a federal component, and then there is the state level component of what we can and cannot do. So previously, in last year, we ran House Bill 83, which went at the criminal component. And that's a very, very important step. We're building upon that with the next layer here. This is going to now ask our employers to go ahead and verify who they are employing. So right now, as an employer, if you have a new employee packet that you pass out to a new hire, you're going to ask them to fill out an I-9 and a W-4. What the employer is going to do is log into the E-Verify website, and you're going to submit that I-9 that they have filled out. And in about 4 to 5 seconds, it can verify whether or not their status is here legal or not. You can get a status that says it's under consideration, meaning there may not be enough information. As an employer, you have at that opportunity, you can go ahead and move forward with the hiring of that person. You can say, hey, we're just going to take a pause until I get a verification on your status. And that's just going to verify whether or not they're here illegally. So on a federal level, they're tracking it. And this allows employers to go ahead and just submit that form. And again, it takes about 4 to 5 seconds. So it's another layer that we're building on this immigration policy work that we're doing here. There's more policies that will come forward, I'm sure, because it's just another layer that builds and builds. There's not one bill out there that you can just pass to solve the illegal immigration level here on a state level. I want to go over some statistics that I think are important. One of the conversations we've had is this going to collapse Idaho's economy? And I will tell you, I think that's not going to happen. And if you look at the state of Arizona, they went ahead and implemented E-Verify. Their numbers came back at about a 17% decline. They noticed that, hey, we've got some work to do here in the state of Arizona. And so it didn't collapse their economy in any way. And I'm not concerned, and neither is my good sponsor, Representative Redmond, that that's going to happen. There's about a 98 to 99% instant confirmation rate with the DHS. And there's 91% employer recommendation rate. So across the United States, they've surveyed over 4,000 companies, nationwide and said, what do you think about this? And over 91% of them said, this is good. You guys need to get this going across the country. So that's what we're going to here. There's no evidence of statewide economic collapse in these states that have mandated E-Verify. So it's good policy, and we're seeing it go across the country. And again, it's another layer that we can provide the citizens of Idaho comfort that we're trying to do the best we can where our federal government has failed us. So thank you, Mr. Chairman.
Okay, committee, any questions for, I guess, either of our sponsors? Representative Barbieri.
Thank you, Mr. Chairman. Representative Crane. It sounds like you're saying that the I-9 we're submitting to the feds are not being used or not being checked. That's got to be inaccurate? Can you elaborate a little bit more on that?
Representative Crane.
Thank you, Mr. Chairman, and thank you, Representative Barbieri. If Representative Redmond feels different at any point in time, he can come forward and speak to that. But currently, if you have them fill out that I-9 and submit it, there should be a check on that. Not every employer is doing that. So I'll just probably leave it at that.
Okay, Representative Crane 13.
Yeah, thank you, Mr. Chairman. Representative Crane 12. So just trying to get into this bill and look at it on, I believe it's page 1, line 34 through 38. It looks like you are defining a federal work authorization program, and you're tying it to U.S. Code 8-1324A. Can you guys explain to me what 8 U.S.C. 1324A is or does?
I'm going to yield my time to Representative Redmond.
Thank you.
Representative Redmond.
Thank you, Mr. Chairman, and Representative Crane 13. What 8 U.S.C. 1324A is, it promotes immigration enforcement without overreach. So it's using the E-Verify system on a federal level. And so we're just following that exact same guidance for the federal guidelines is for E-Verify.
Follow-up,
Thank you, Mr. Chairman and Representative Redmond. So if the feds go in and change 8 U.S.C. 1324 to require something that we don't agree with, how are we going to address that moving forward?
Representative Redmond.
Thank you, Mr. Chairman and Representative Crane. We would need to address that legislatively. Again, we're following that federal guidance that we have in federal code currently, and so that's what we would need to do.
Okay.
And one more minor update, I think, just to clarify during the testimony, the 17% decline in Arizona was for illegal workers. It was not for the economics. Actually, the economy continued on just as if nothing had happened.
Representative Green.
Thank you, Chairman and Representative Redmond. I have a question pertaining to the threshold that makes this mandatory. Are we talking all employers, or are we talking employers with 15 people or more?
Representative Redmond.
Thank you, Chairman and Representative Green. We are talking all employers. The thought there was we had played with, different employee thresholds. The thought was doing it universally kind of sets an even playing field for all. And again, because it's not that difficult a burden to apply, it's free. It doesn't take a whole lot of time. We felt like we should implement it for all employers.
Follow-up, Representative Green.
Yes, thank you, Chairman and Representative. So thank you for verifying that. And so the follow-up question I have is, I haven't had to use this. How long does it take for once you enter the information to get a response? And then also, how do you know that the person's information you're entering is actually valid, right? We recognize that a lot of stolen identities is prevalent. So how do we address that?
Representative Redmond.
Thank you, Mr. Chairman and Representative Green. So after the information's entered, about 98.5% of the time, it's an instant response. So within a couple seconds. And as Representative Crane had mentioned, sometimes says not validated yet, and that may take a little extra, but 98.5% of the time it's immediate. And then you're right. I mean, there could be, identity theft. Unfortunately, this bill is set up for the good actors trying to comply with the law. We can't necessarily plan for everything, so.
Representative Crane 13.
Yeah, thank you, Mr. Chairman and Representative Redmond. On page 2, line 17, you're outlining, it looks like a government identification document bearing a photograph or a biometric identifier. What is the need for a biometric identifier?
Redmond.
Sorry, Mr. Chairman, Representative Crane. So it is a photograph or biometric identifier. That would be, I guess, if they did not have a photo ID.
Follow-up?
Thank you, Mr. Chairman and Representative Redmond. So towards the bottom of page 2, top of page 3, you give other things, social security card, a birth certificate, valid passport, but you don't have a biometric identifier in that portion of the statute. So why is it not acceptable down in that portion of the statute?
Representative Redmond.
Thank you, Chairman and Representative Crane. I believe it could be acceptable there. However, we have the valid IDs, the photo identification, just don't have it there as far as the next part of authorization.
Follow-up, Representative Crane?
Chairman, and so Representative Redmond, so what are you envisioning biometric would be? Would it be a scan of your fingerprint, a scan of your eye? Is it a unique identifier that's handed out by the government to individuals? What is the bio-identifier?
Representative Redmond.
Thank you, Mr. Chairman. The bio identifier that I would envision would probably be a fingerprinting.
Follow-up,
Yeah,
Representative Crane?
thank you, Mr. Chairman. And Representative Redmond, sympathetic to your legislation. I'm very concerned about the biometric identifier. With it not being defined, we're in a brave new world. And so this gentleman has some concerns about that, and you and I can talk offline. I don't want to hold up what you're trying to do, but I think that that's something we might want to chat about. Thank you.
Thank you, Mr.
Representative
Chairman and
Redmond, do you want to
Representative.
respond to that?
Yeah. I'm happy to talk offline and come up with a solution for you.
Representative Barbieri.
Thank you, Mr. Chairman. Representative Redmond, I'm wondering, so as an employer then, I submit this, immediately I get some response. I need to print that response out and put it in the employee's file so I have proof that it's been done? Or what's the proof that I'm going to use?
Representative Redmond.
Thank you, Mr. Chairman and Representative Barbieri. Forgot my seatmate's name. Yes, I would keep it for the records. However, it will be on the E-Verify system and logged with the federal government at that point. So there is verification there with them.
Okay. Chairman, I had a question maybe related to Representative Green's question. If I hire a neighborhood kid to come mow my lawn, rake leaves, do I read correctly that House Bill 704 would require me to enter his or hers information in the E-Verify system?
Thank you, Mr. Chairman. If you're hiring somebody, as just a employer, and they don't have an established business, I don't know that you would need to be using the E-Verify system. I understand your concern there. Obviously, that's not the intent of this legislation, but I don't believe that you're going to be required to verify, kids mowing lawns and that type of thing.
Oh, Representative Crane, 13.
So you spurred a question. So, Mr. Chairman and Representative Redmond, so my lawn guy that I do hire, that is a legitimate business, do I then, since I'm hiring him, have to run him through an E-Verify system to make sure that he is a legal guy?
Chairman, Representative Redmond.
Thank you, Mr. Chairman and Representative Crane. No, you would not have to because you are the patron at this point. So that person that's doing your lawn, he's performing services for you, but you are not the employer or even the subcontractor at that point.
Follow-up, Representative Crane.
Thank you. How does that work in your building? Because I view myself as the employer because I've hired him to perform a task for me. How would I not be employing him legally in this bill? I'm trying to understand if I'm paying him, he's coming every week to clean, mow the grass. How am I not employing him and him considered an employee of my operation?
Representative Redmond.
Thank you, Mr. Chairman and Representative Crane. I think it's the same way that if you went to a restaurant and were eating food there and being patronized, you're the patron at that point, right? They're performing services. You're not necessarily employer. You're paying for a service, but you're not necessarily employing him at that point. You're just paying for the service that he's conducting.
Well, as long as I'm spurring questions in Representative Crane, he spurred one in me. In that same area, top of page 3, bottom of page 2, one of the documents it's talking about is social security card, and it talks about valid passport, valid photo identification. I'm just curious, What happens in a situation where there are some social security cards that are issued that literally say not valid for identification? What happens if somebody tries to use that as the valid? Just walk me through that if you wouldn't mind.
Absolutely, Mr. Chairman. So, there's a number of different forms of identification if they did have one for not used as a identifier. So, you could follow up with any of the other uses that you have there. At some point, we just want to make sure we are verifying the identity to get away from identity fraud.
So just a brief follow-up to that, because in that same section, it says a valid passport. But would that mean if someone has a passport from some other country, Zimbabwe, and it wasn't a U.S. passport, that it would count as valid identification?
Thank you, Mr. Chairman. That would be valid identification. However, it would be checked within the E-Verify system to verify legal status.
Representative Harris.
Yeah, thank you, Mr. Chair. Just for a comment on some of the questions that have been coming up. I dug into the biometric part of this bill, and that is actually a process that happens at the very beginning stages of the visa process, where the federal government requires you to sit down and take fingerprints, photo ID, and then they run that through the FBI's background check to see if you're actually a criminal in the country you're coming from. So that's where the biometric part comes into this bill. And then to touch on, the guy mowing your yard, that would be considered a subcontractor. And as such, they are not your employee. They're a subcontracted business to come do work for you, which would not be under this bill if I read it correctly.
Okay. Thank you, Representative Harris. Representative Green.
Thank you, Chairman and Representative. A couple things, because I'm going to go down this conversation about hiring someone. And so I hired a campaign manager, right, to do some, work on my behalf. And it's one person. Do I need to verify and go through E-Verify and get their birth certificate and do all of those things as well if they're just a standalone one person conducting business?
Representative Redmond.
Thank you, Mr. Chairman and Representative Green. I think along those same lines, I think you're hiring them for a service. You're not necessarily employing them, so I do not believe you would have to.
So
Follow-up, Representative Green.
thank you, Chairman. Yes, and thank you, Representative. So where in here does it say that? I guess that's where I got hung up on the number of employees, because I may be hiring them to do a service, but at the same time, I feel like I'm obligated, right, according to this legislation. And furthermore, and I'm going to reference this handout from the Dairymen's Association. Furthermore, the stipulation that private citizens can petition the Attorney General to investigate noncompliance, right? So I'm really weary about getting noncompliant and then having the AG investigating us. So does it say in here that it has to be an employer relationship, or is there something in here that says if it's for services, it doesn't apply?
I heard a couple questions there. Representative
Sorry.
I
Redmond.
heard a couple too. Thank you, Mr. Chairman and Representative Green. Again, the thought of this is for that employer-employee relationship. It's not necessarily for, having services or a patron, actually. And then as far as the other concern with the AG, again, we're looking for unauthorized workers, right? We're not necessarily trying to actually create more burden at all. And it's a pretty simple task. Again, we all comply with it currently as state employees, and I do believe that it would not be burdensome at all. And I don't think we're going to have a whole lot of that, I went to a restaurant and received some food, and now all of a sudden that's that's an employee. No, they performed a service, and all we're doing is, using them as a patron.
Representative Razor.
Thank you, Mr. Chairman. If I may comment on this?
You may.
I hired certified security recently to fix a camera. I will not be filling out a 941 for them. I will not be collecting Social Security and putting it into the EFSTP format online. I hired them to do a service for me. This is the major difference. So at the question of the lawnmower, if you're actually going to sit down and calculate his Social Security tax and his Medicare and his federal withholding and his Idaho withholding, then you're employing him. But if you're just paying him for the service, then he is not your employee. I think that's what we need to recognize about this particular bill, which I think you handled that very well in the language of the bill.
Thank you, Mr. Chairman, and Representative Razor answered that quite well. So.
Representative Crane, 13.
Thank you, Mr. Chairman. Let's go to the bottom, the enforce, where it goes into effect. So it's July 1, 2026. So we're talking 5 months. I know when I've heard the dairy industry talk about this, for example, the number's been thrown out there that like 70% of the employees in the dairy industry are illegal. So let's talk about, get down on the granular level. How is this going to play out in Main Street, Idaho, or on the dairy in Idaho, maybe a better way to say that. If this goes into effect, they have 5 months in order to replace 70% of their workforce and make sure that the milk still continues to flow and cows don't die. Have you thought about possibly giving them more time? I mean, 5 months, I know I've been trying to hire for a couple of years, individuals. So do you feel like 5 months is enough time for the dairy industry, and you can insert whatever other industry you want in there to get their employee workforce replaced, trained, ready to go, so there's no interruption in services?
Representative Redmond.
Thank you, Mr. Chairman and Representative Crane. I think we did have some of those discussions. We finally came down with the 7/1 effective date. However, open to input. I think our thought was, this is something that's been going on for a long time. We've been circulating this around. I think probably a lot of folks were aware that this was going to be coming back, and we're just trying to solve a problem here. But I do understand the concerns, and that is something, again, maybe we can talk about that offline too.
Okay, thanks.
Representative Birch.
Thank you, Mr. Chairman. First, a question for you. Do we have people signed up to testify for or against this bill?
Representative Birch, we do have people signed up to testify both for and against this bill.
Okay. Well, and then, Mr. Chairman.
Follow-up?
A question for the sponsor.
Go ahead.
Thank you, Representative. Can you quantify the economic damage that is currently being done to the state that would be rectified if this, that's currently taking place if this bill doesn't become law?
Representative Redmond.
Thank you, Mr. Chairman. And just to make sure I understand your question, Representative Birch, existing damage without this bill?
Yeah, excuse me, I'll clarify, Mr.
Please
Chairman.
clarify,
Yeah, I
Representative
just want to make sure I understand that. If we don't pass, if this doesn't become law, is there currently economic damage that's being done to the state in the absence of having this be law?
Representative Redmond.
Thank you, Chairman and Representative Birch. I don't know that I can quantify any existing damage being done without this, but I think the study from Arizona which implemented a bill very similar shows that there won't be damage with adding this. And again, this is in search of what we believe is an issue within the state, and we're just trying to abide by the law.
Follow-up, Representative Birch.
So in regard to your answer there, are you saying that no stakeholders in this bill have indicated that this would be of economic damage to them if this became law?
Representative Redmond.
Thank you, Mr. Chairman and Representative Birch. I think there's something about asking a question that you know the answer to. We do know that there is.
Actually, quite honestly, I
Yeah.
don't, because you're making a statement that implying that because of what happened in Arizona won't be a problem here, and I'm wondering, because I actually haven't spoken to anyone about this bill, believe it or not.
Really?
And really, that's absolutely true. So I would like to know, if any of the stakeholders that'll be impacted by this are in fact telling you that regardless of what happened in Arizona, that this would be of economic damage to them here in Idaho.
Representative Redmond.
Thank you, Mr. Chairman and Representative Birch. We have heard from stakeholders saying that there would be damage because, as Representative Crane mentioned, there's the dairymen have said that they do have some folks that they do not believe are here legally. And so we have heard that there would be damage. I guess my Arizona study was to counter that and saying that Arizona didn't see the significant damage that we've been told we would see. Yeah.
Okay, committee, not seeing any additional lights. We do have testimony on the bill, and I'd like to give about 30 minutes, give or take some amount of time for the testimony to occur. So we will start first with a Michael Angeletta. If you'll come to the podium and introduce yourself for the record, you'll have 2 minutes to testify.
Thank you, Chairman, members of the committee. I'm Michael Angeletta. I'm here on behalf of Secure Idaho, and I would argue up to 80% of Americans who want real immigration reform and immigration labor reform. And I'm here to testify on behalf of HB 704. This bill reflects that consensus. I'm a small business owner myself. I believe in limited government and free markets. Free markets, however, only work when everyone plays by the same rules. Idaho law already says you can't knowingly hire unauthorized workers. It already says that. But without universal verification, that law becomes optional. And when it's optional, honest businesses like mine, we lose. If I follow the rules, but my competitor cuts labor costs by hiring illegal workers, that's not competition. Candidly, it's cheating. I've spoken with farmers and builders also across Idaho leading up to this testimony. Many are deeply frustrated and angry about the illegal labor situation and immigration situation in the country and the state. But they're unwilling to testify here publicly because speaking carries professional risk within their industry. When rule-following employers are frustrated in private but hesitant to speak up in public, the playing field isn't level. This bill protects those quiet, rule-following businesses. Now, I want to address a couple of quick objections. First, we hear it won't work or that it's going to create some great recession-like impact on the economy. We've already heard about Arizona, and there's a reason. They've done it for 20 years. There's another reason. We have peer-reviewed research and data on it. It's not a mystery to us. And if we actually look at their building and dairy industries, they're doing great. Their dairy industry is one of the biggest in the country, and they have E-Verify now for 20 years. The dire predictions, they simply didn't materialize. Second, we hear it's too burdensome. I'm actually going to, they already mentioned it's a good job. It only takes 15 minutes. My business, it took me less than 10 minutes to enroll. It takes seconds to verify somebody. It's free. It's actually for a federal government system. It's actually amazingly easy to use, shockingly.
Mr. Angeletta, if I can have you wrap up, please.
Sorry, sir. I'll leave it at this. Limited government does not mean no enforcement. It means clear laws applied evenly. This bill enforces the law already on the books. It protects Idaho workers, it protects honest businesses, and it ends the advantage given to those who simply ignore the law. I respectfully ask for you to support HB 704. Thank you.
Thank you, Mr. Angeletta. Representative Crane 13. Mr. Angeletta, it looks like there may be a question for you.
Thank you, Mr. Chairman and Mr. Angeletta. How do you feel about giving those individuals that are struggling with finding a workforce like the dairy industry, how do you feel about giving them time? So maybe put an implementation date of July 1, 2027, for example, or 1/1 of 27. Are you open to that?
I understand your concern.
Mr. Angeletta?
Yes.
Go ahead.
And I'd like to address the underlying concern, which is if we lose 70% of dairy overnight, what happens? For example, this is for new hires. Not existing hires, new hires. So that workforce doesn't disappear magically overnight for anybody. Does that help?
Representative Crane 13, follow up?
Yeah, thank you, Mr. Chairman and Mr. Angeletta. It does, and I appreciate that. But also, they have no idea if the workforce decides to walk off the job because they're scared, right? So is there some thought into extending the timeline a little bit longer to help them implement and work with those industries, at least get the law in place? I mean, this has been a problem the whole 20 years I've been here, but at least get the law in place, but give them some time. Would you guys be amenable to that?
Mr. Angeletta?
As a business owner, I would say that's reasonable.
Okay, thank you.
Committee, any other questions for Mr. Angeletta? Okay, thank you for your time, Mr. Angeletta.
Thank you.
Next up, we'll have David Pettinger. Mr. Pettinger, if you'll please come to the podium, introduce yourself, and you'll have, for the record, you'll have 2 minutes to testify.
El jefe, amigos, mi interpreter is presente. Señor Skip Benick.
Mr. Chairman.
Representative
No
Birch.
hablo inglés.
Mr. Chairman.
One moment,
pardon?
Mr. Pettinger.
Point of order.
Representative Birch, go ahead.
This is not performance theater here. If we can please have straight testimony. Otherwise, I don't think this is appropriate form of testimony for this committee here.
Okay. Thank you, Mr. Birch. I agree, Mr. Pettinger. If you can please deliver a straight testimony. If not, we'll move on to the next testifier.
Sí, en español. En español.
Mr. Chairman, could you just put the committee at ease?
Representative Crane, let's do so. Committee will be at ease.
Thank you.
All right, Mr. Pettinger, I think we had just over a minute left in your testimony, so if you'll please resume, and again, as we agreed, please deliver a straight testimony.
Sure. And thank you, Chairman and Committee. I think I had a little bit more time. I never saw the clock or the timer. I don't know if it's going or not. But anyhow, I was going to argue against this in Spanish and thus the character of the concerns of illegal immigration and their use of employment by large employers, and actually brought my Spanish interpreter, Skip Bannock, today because I needed some help with some of that issue. But what I would say, I had signed up to be against the bill as an illegal alien because, you know, we have our local law enforcement that allows them to run throughout the community through the non-compliance with the 287G program, which is not this bill. But we have employers, you know, present in the room, lobbyists from Simplot, Dairymen, we have, you know, Chobani, we have Amdi Ulakaya, we have the Tent organization that brings in refugees from around the world that led will be familiar with in southern Idaho as to, you know, the rape of underage girls by some of the people that were employed and brought into that community. So this is a very concerning bill. I still don't know where we are on the timer here.
5 seconds, Mr.
Oh,
Pettinger.
5 seconds. It's tough when you guys aren't running the screen there because we don't actually know where we're at or know if public broadcasting is doing its job. But anyhow, I would say that, keep going. This bill is a good bill. I was looking forward to giving you some entertainment, and I think that you would have enjoyed that testimony substantially more. But considering that I don't want to end up in these handcuffs again by your friends from the Idaho State Patrol in the back, we will just leave it at that.
Okay, thank you, Mr. Pettinger. Representative Green. Okay. Thank you for your time, Mr. Pettinger.
Okay.
We'll move now to Lydia Strong. Lydia, if you'll please come to the podium, introduce yourself for the record, and you'll have 2 minutes. I do apologize. We're having a minor technical issue, and so, believe it or not, you have to trust your vice chairman with the amount of time that you're being given.
Thank you, Chair, Vice Chair, and members of the committee. Thank you for the opportunity.
Ms. Strong, can you pull your mic down just a little bit closer? Thank you.
Thank you for the opportunity to be here. My name is Lydia Strong, and I support this bill. Justice is the reason I left Brazil. As a lawyer, I fought for justice in the country, but it became increasingly difficult as the rule of the law weakened. I come to the United States legally because I believe this country stands for freedom, opportunity, equal application of the law. I follow every legal requirements because I respect the law. That respect is what ultimately led me to become an American citizen. Today, many legal immigrants like me feel that something fundamental is being eroded. When people enter to work in this country illegally and face no consequences, it creates the perception that the law applies for some but not for others. That is no justice. This bill does something simple. It requires employees to verify work eligibility usando an existing federal system. It does not target immigrants like me. It reinforces equal enforcement of the law. The rule of the law means everyone is subject to the same standard. No exceptions, no favoritism. That principle is what drew me to America, is why I become a citizen and proud to be America. And is why I urge you to support this bill. Thank you, and I'm happy to answer any question.
Okay. Thank you, Ms. Strong. Looks like there aren't any questions for you. Appreciate your time.
Thank you, committee.
We will move now to Scar Rulian. No, I'm sorry. Let's see here. This will be an online testimony. Okay, Ms. Rulian, if you'll introduce yourself for the committee, for the record, you'll have 2 minutes to testify.
Hi, I'm Scar Rulene. I'm a concerned citizen of Twin Falls, Idaho. I'm here to talk about why E-Verified is a flawed system that should not be extended. I oppose HB 704 as an Idahoan with common sense. Extending E-Verify systems is a waste of our state's time and effort. According to a study done by the University of Idaho McClure Center for Public Policy Research, in Idaho there are an estimated 35,000 unauthorized immigrants in the workforce. There are 1 million people in Idaho's labor force total. Why is Idaho spending time and money targeting such a small amount of the working population instead of investing time and money into legislation that creates new jobs? This bill will crush small businesses with compliance costs. It's not easy to implement a program with a 64 basic user manual. With a 64-page basic user manual, it takes time, and that time translates to money. Businesses who don't want to go through the process of vetting their compliance on their own will be required to use expensive third-party software to manage E-Verify compliance. That is not to mention that these systems are vulnerable to errors and delays. Small businesses, regardless of whether or not they employ unauthorized immigrants, will feel the costs associated with introducing this unnecessary program. According to the American Immigration Council, when Arizona introduced a similar bill, they saw an increase in under-the-table hires and a reduction in tax revenue. Small businesses reported having initial setup costs ranging from $1,254 for businesses with 10 employees and up to $24,442 with 500 employees. It costs around $127 per new hire query. These prices are absurdly high for the effect of putting 35,000 people at work. I urge you to vote no on HB 704.
Okay, thank you, Mr. Ullin. Appreciate your being here to testify. We will move now to Nissa Nagel. Ms. Nagel, if you'll come to the podium, introduce yourself for the record, and you'll have 2 minutes to testify.
Hello, my name is Nissa Nagel. I am here testifying on behalf of myself. I am a bookkeeper with more than 20 years experience in business administration. I am against House Bill 704. An employment eligibility verification process already exists. The federal I-9 requires all employers to verify employment eligibility. It's not just a form filled out by the new employee. In fact, the I-9 requires the employer to view the person's documents. There's Schedule A, Schedule B, and Schedule C. They also have to attest to the validity of those documents. There are penalties if they fail to do this process. E-Verify is an additional burden for employers that doesn't even protect them from facing unwanted ICE attention. It is a flawed system. In a 10-year time period, there were 130,000 documented errors leading to eligible employees and employers missing opportunities, consequences for people trying to feed their families and businesses trying to hire for agricultural and dairy industries. This burden extends to families who hire home healthcare workers and nannies. Due to a shortage of space in daycares and elder care facilities, this is a serious issue. Household employees that pay their employees more than $3,000 in a year are considered a household employer, and therefore they would have to do E-Verify. A family dealing with the stress of a parent's sudden decline should not have this additional stress. Use of E-Verify adds to the unnecessary collection of personally identifiable information in a remote database where people's information can be misused by other agencies. Curious that Idaho wants to fuel the surveillance apparatus of the federal government. Thank you.
Thank you, Ms. Nagel. Okay, we will move now to Charles Strong. Mr. Strong, if you'll please come to the podium, introduce yourself for the record. You'll have 2 minutes to testify.
Thank you, Mr. Chairman, committee. My name is Charles Strong. I'm a retired U.S. Air Force officer and married to this wonderful woman that just testified about coming here from Brazil. Lydia and I both spent a lifetime and a career in compliance and verification. I went through, to become an Air Force officer, I had to go through verification of who I was and be able to pass the security clearance. My wife and I had to go through this process to be able to bring her here. We had to get a fiancé visa. She had to be checked in Brazil to make sure she didn't have any criminal record. Then we had to go through the entire process of verification that who she was and why is she coming to the United States? We went through that entire process, paperwork, filling it out, going through physical examinations and inoculations. We had to go through that, and it had to be verified. Then when she came here with her fiancé visa, we had to go through, once we were married, then we had to go through and get the green card. And again, we had to fill out the paperwork, pay the fees, and comply with the law and verify that who she is and that she's here lawfully. Then when she became a U.S. citizen, she had to do the same thing. We had to go through the process. We had to verify who she was, that she didn't have a criminal record, and that she's been in compliance with the law. All I'm asking here is that we comply with the law and that we verify people that are coming here, just as much work as we had to do to bring her here and to spend a lifetime together. I'm asking you to do the right thing, to not reward lying and cheating and stealing. Because when I was a cadet, that's what I was told. You do not lie, you do not cheat, you do not steal or tolerate those who do. Please don't tolerate those who do. Thank you.
Thank you, Mr. Strong. Okay, next committee will move to Nixon Matthews. Nixon, if you'll come to the podium, introduce yourself for the record. You'll have 2 minutes to testify.
My name is Nixon Matthews. I am a resident of District 16, and I am here in opposition to HB 704. This bill is being framed as a simple employment verification bill, but in reality, it requires virtually every employer in Idaho to enroll in E-Verify and run all new hires through a federal database and has harsh penalties attached. This is a major expansion of government authority into hiring decisions in Idaho, and it will land squarely on small businesses. 99%, over 99% of businesses in Idaho are small. Over 73% of Idaho's employers have fewer than 5 employees. These are not large corporations with compliance departments. They are small contractors hiring a couple of workers for a short-term job and family-owned businesses hiring someone to help cover shifts. And this bill puts all of them in a federally managed verification system with strict requirements. And it all rests on E-Verify, a database that does make mistakes, from simple name mismatches and paperwork errors to data entry errors that flag U.S. citizens and authorized worker. This is a flawed system. And so when risk is that high and employers will protect themselves. They will avoid hiring people they think could create complications, being immigrant workers, mixed status families, and communities already facing aggressive enforcement. You do not have to write discrimination into a bill for it to produce discrimination. You only have to structure it so avoiding certain workers feels like the lowest risk option. I'm going to use the 18 seconds I have to say what happened today is unacceptable. That man should have been removed from this room. There are
Mr.
people
Matthews,
who are
that's
watching
enough.
this.
I'm going to ask you to please take your
Worried.
seat. We handled that in the way that we best saw fit. Thank you for your time. Thanks for being here. We're going to move to Carlos Vidales. Carlos, if you can please come to the podium, state your name for the record. You'll have 2 minutes to testify.
Mr. Chairman, thank you very much, members of the committee. My name is Carlos Vidales. I stand in support of HB 704. I am an immigrant myself. I came to this country legally. I applied for legal residency. I became a citizen. I have been a citizen for 4 years. The system works. You have to be patient. You have to be persistent, but it's not that difficult if you follow the rules. I'd like to first address the issue of E-Verify. I have been E-Verified myself by my employer. I have also run E-Verified myself for my own subordinates. Those are the times. I can testify that the system is easy, fast, and if you have any doubts why it is so easy to verify and why it's necessary, I can explain to Representative Crane or anybody who asks how it works, and it's so easy to verify. So the very first act an illegal immigrant commits in the United States is to break the law. And when they seek illegal employment, they break the law once more. So if the country cannot make sure that the laws are obeyed, what is the purpose of it? A nation built on laws cannot ignore repeated violations of those laws without severe consequences. The United States is a prosperous country in large part because we obey the laws and play by the rules. When we allow illegal immigrants to obtain employment, we reinforce the idea that breaking the law is acceptable, even if it produces a positive economic results. It is the wrong message from our society. I can tell you, I came from a country where the rule of law is a joke. This is not something that should be allowed in this country. Ignoring illegal employment also harms legal immigrants like myself. Millions of people around the world are following the rules, are waiting their turn, respecting the system. When illegal employment is tolerated, it undermines the sacrifices and disciplines of those like me who have chosen to do things by the law. So that is a conclusion. I like to appreciate it. So if I love this country, I became a citizen. I don't want to be anywhere else. I'd like to support HB 704. And if you have any questions for me, I'll be glad to answer them.
Thank you, Mr. Vidalis. I don't see any questions, but appreciate your time. Committee will move now to Bill Cooper. Bill, if you will please take the stand, state your name for the record. You'll have 2 minutes to testify.
Thank you, Mr. Chairman and committee members. My name is Bill Cooper. I am a retired chief of police, and I have more than 30 years' experience in law enforcement. In law enforcement, clarity matters. Uniform standards matter. Consistent, equal enforcement matters. When laws exist but are not applied fairly and evenly, it creates confusion, frustration, and loss of public trust. I know, I've seen it. This bill, as has been testified to, does something simple. But from a public safety perspective, employment is a major pull factor in illegal immigration. When employment of illegal immigrants is available, it attracts even more violations of the law. It supports illegal actions, but does not support fair, unbiased enforcement of the law. This bill does not create a new government bureaucracy. It relies on an existing system. It gives the Idaho Attorney General enforcement authority. The clarity here we're talking about supports law enforcement. Right now, Idaho does not have a good grasp on the actual numbers, the costs. I'm a Lean Six Sigma Master Black Belt. Data matters. It actually counts. One of the basic premises there is that if you can't measure it, you can't manage it. This bill creates structure, accountability, and deterrence. It protects lawful workers, it supports rule-following businesses, and reinforces respect for the law. In my judgment, consistent enforcement of employment law strengthens public safety and public confidence. I encourage you to support this bill. Thank you for your time, and God bless you.
Thank you, Mr. Cooper. Committee, any questions for Mr. Cooper? Okay, seeing none, thank you for your time. Committee, we're going to move now to William Mostoller. If you'll please come to the podium, state your name for the record. You'll have 2 minutes to testify. And committee will have 2 more public testimonies after that.
Good afternoon, Mr. Chairman, committee, thank you. My name is William Mostoller. I'm a United States Marine Corps veteran. I served Iraq, Afghanistan with 3rd Lateral Reconnaissance Battalion. I survived multiple IED blasts and injuries such as traumatic brain injury. Construction has been the trade that's allowed me to rebuild my life. I have worked in the trades since 2003. I've raised 6 children and a family on a single income. My children have wanted for nothing. Over the last several years, I've watched as it has become harder and harder for tradesmen to not only obtain good quality work, but they've had to fight over these scraps that are left behind where new construction and larger builders than myself have switched to mostly illegal labor. This has created quite a strain, especially in the Magic Valley. I know many tradesmen who are sitting at home right now that cannot get work because other people are fulfilling those jobs. This isn't just about wages. It's also about quality of work. I have personally seen serious code violations, dangerous installation tied to illegal crews that did not understand building standards. I have seen structures completely reframed because they were unsafe to go into. I have watched improper installation of systems that caught fire, and I have personally put those fires out. Idaho families deserve safe and strong homes built by trained workers who are here legally. HB 704 simply requires employers to verify legal work authorization.
Mr.
Using
Mosteller, if I could have you wrap up, please.
Yes, sir. I just ask you to please support this bill.
Thank you for your time. Oh, so any questions? Okay, we'll move now committee to Tim O'Donnell. Mr. O'Donnell, if you could please come to the podium, state your name for the record, and you'll have 2 minutes to testify.
Thank you, Mr. Chairman, committee. My name is Tim O'Donnell, representing also Secure Idaho. We're a nonprofit grassroots organization of volunteers. We urge the committee to support this bill. Our group selected immigration reform policy this session because public policy on illegal immigration is not in line with public sentiment. Recent Rasmussen polling showed that 75% of Republicans want all illegals out. In a very red state that overwhelmingly went for Trump, whose signature issue was mass deportations, it should be very clear where the public stands. I think Republican legislators understand that a survey of the Republican caucus last session identified immigration as a top 5 issue. And I just want to say, come here the right way. I appreciate the stories over there about people, what they go through to get vetted as to who they are and why they're here. We can't skirt that. If you really want to do something effective on illegal immigration, in this state, this bill is it. A mandate on all employers to use E-Verify will have the biggest impact on illegal immigration. That's not just my opinion, but the conclusion of several studies. One study, for example, Arrhenius and Zavodny, quote, our results indicate that requiring employers to use E-Verify has a large negative effect on the number of unauthorized immigrants in a state, end quote. This is not untrodden territory. Other states have similar bills for over a decade. There's been numerous studies that have been done on the effects. No ruinous depressions or recessions, no destruction of ag, hospitality, or construction industries. Meanwhile, illegal populations went down. This bill will make that happen here in Idaho. Thank you for your time and consideration.
Okay, thank you, Mr. O'Donnell. Don't see any questions. So committee, finally, we'll have Mr. Rick Narabau. Mr. Narabau, if you'll come to the podium, introduce yourself for the record. You'll have 2 minutes to testify.
Thank you, Mr. Chairman. Chairman Wheeler, members of the committee, I am Rick Narabau, and I represent Idaho Dairymen's Association. It will not come as a surprise to this committee that the Idaho Dairymen are opposed to House Bill 704. The reasons we are opposed to this bill are many, and we have been very transparent about our workforce and how frustrated and unsatisfied we are with the status quo. That is why we are working diligently at the federal level to solve this issue with Congress and President Trump, so the state of Idaho and our ag economy can remain strong. Evidence we are making progress are reflected in the president's comments just this January. He stated, I would love to have a comprehensive immigration policy, something that really works. He went on to say that he wants critical industries like agriculture spared, and their workers need to be able to stay in country if they have been here and have not committed a crime. If the state of Idaho creates a patchwork of E-Verify regulations, employers risk losing access to a workforce that could cause significant harm. That's why we urge this legislation to be put on hold until President Trump and his administration complete their work and solve this at the federal level, which in fact is where the U.S. Constitution says is the rightful jurisdiction for immigration policy. Idaho Dairymen appreciate that the intent of House Bill 704 is towards attaining a legal workforce. But the reality is that E-Verify is a flawed federal program that costs money to implement and doesn't provide accurate results, which has been demonstrated in states like Nebraska and Georgia. I would request that the economic report released by the Idaho Alliance for a Legal Workforce, which details the harm policies like E-Verify could cause the state of Idaho, be submitted for the record. In short, losing a critical workforce across multiple economic sectors could cause another great recession in Idaho. That's something none of us want to see. Thank you, Mr. Chairman and committee members, and I'd be happy to stand for questions.
Representative Harris.
Yeah, thank you, Mr. Chair, Mr. Narabal. So while we're sitting in limbo waiting for the federal government to act, and arguably this bill doesn't have anything to do with immigration, it just has to do with enforcing laws in this country that we have that prevent you from hiring illegal immigrants. So while we're waiting in limbo for the federal government to do something, are we supposed to continue to allow people like the dairy industry to just flagrantly break the law?
Mr. Narabal.
Chairman Wheeler, Representative Harris, first, I'd like to correct the record that our dairymen do not flagrantly break the law. We complete I-9 forms just like every other employer, and we don't believe it should be on the employer to verify legal status of an individual in country. That should fall on the government, not an employer. Secondly, I would point towards in the transcript of the interview I referred to with President Trump, he was bluntly asked the question, do you feel like ag workers and those in critical industries should remain in country, and have you asked your agencies to limit their enforcement? And he bluntly answered, yes, I have. So I would suggest we follow President Trump's lead, allow him the space to work on this, and allow there to be a federal fix come forward.
Follow up,
Representative Harris.
Thank you, Mr. Chair. So does the dairy, ag, any construction industry across the state in Idaho, but speaking to dairy specifically because that's who you represent, do they knowingly employ illegal immigrants in the state of Idaho?
Mr. Narabal.
Mr. Chairman, Representative Harris, no, we do not knowingly hire undocumented or unauthorized individuals in the state.
Representative Crane 13.
Thank you, Mr. Chairman and Mr. Narabal. So you reference work that's being done on the federal level, and I think there's an H-2B program, H-2A, H-2B, one of them, that works for the sheep industry. Is that correct?
Mr. Narabal.
Mr. Chairman, Representative Crane, yes, that's correct. The shepherds have access to the H-2A program and have a special provision within the H-2A program that allows year-round labor.
Follow-up, Representative.
Thank you, Mr. Chairman. Mr. Narabal, has there been any conversation or thought to H-2A would cover ag, H-2C would cover construction, H-2, so as each industry can come up with a workforce that works for them, is there any conversations taking place on the federal level to do something and to mimic what's happening in the H-2A program?
Mr. Narabal.
Mr. Chairman, Representative Crane, yes, absolutely. Congressman Simpson has been part of introducing Farm Workforce Modernization Act. That is a bill that would specifically expand the H-2A program to year-round agriculture. Right now, that program is explicitly just a seasonal and temporary program, so we, as year-round ag employers, are not allowed to use it. And so the conversation has been to extend that program and allow those of us in year-round agriculture access to it, so then we can forego this issue and not have this be something that we have to continually debate, and we can actually get to a point of a solution.
Follow-up,
Yeah,
Representative
thank you, Mr. Chairman. But I understand it's not just, so dairy's got an issue, ag's got an issue, hospitality's got an issue, construction we're hearing here now has an issue. Are all those industries getting together and saying, look, we have a problem, we need a workforce, and Congress, we need a solution? Or is it just, what's happening? I mean, it's hard to fathom that nothing's moving. If there's a significant problem, there's 70% of the people want this issue resolved, and Congress isn't doing anything.
Mr. Narabal.
Chairman Wheeler, Representative Crane, yes, all of those industries, we have gotten together. That Idaho Alliance for a Legal Workforce is a coalition of all those employers to work on this issue collectively. I can speak to the agricultural issues. Construction's in the room to speak to the construction issues. Hospitality's in the room to speak to the hospitality issues. So yes, we very much are working collectively to try and solve this problem and be proactive, because none of us like the risk that this poses for our businesses.
Representative Birch.
Thank you, Mr. Chairman, for a question.
Go ahead.
As I understand it, and if I'm wrong, I welcome the sponsor to correct me, but my understanding is that any private citizen can file a claim with the Attorney General claiming that there is a non-compliance situation, and there's no penalty whatsoever for anyone making a baseless claim. Can you give me a sense of how that would affect the daily life of of the members of your organization if they found themselves being, the receiving end of an unlimited number of baseless claims that people don't have to pay any consequence for making.
Mr. Nearbow.
Chairman Wheeler, Representative Birch, yes, our read of this bill is that there is that provision that a citizen can file a complaint with the Attorney General's office without penalty if there's no validity to the complaint. The concern would be that you would have limitless complaints come at Idaho ag employers. That is a significant concern. And it gets to a question that Representative Crane brought earlier in the session, in that, yes, this is for only hires going forward, but a dairy producer would have the risk, or any other employer that had the possibility of an unauthorized worker in the workforce would have the risk that if they were investigated, then they could lose more than just the new hires. And so this does get at existing employees as well.
Mr. Nearbow, I just have a question, if you could help me understand, and this may be unique to dairy, but the fact that you have seasonal workforce, and I understand that HB 704, as it's currently written, theoretically only applies to new employees going forward, but what is the percentage of the dairy workforce that routinely stops employment at the end of the season and then resumes employment in a following year?
Mr. Chairman, we don't have seasonal workers in the dairy industry. We have year-round operations that run 24/7. So we don't ever have that seasonal aspect to what we do, like you would see in row crop or other sectors of agriculture, where you've got about a 2-month gap where you don't need workers on site. We never have that luxury. We always are running our operations 24/7.
Okay, I don't see any other questions. Mr. Nearbow, thank you for your time, and I'll return the podium now to the bill sponsor to close your presentation.
Mr. Chairman, point of clarification, where for this to be submitted to the record?
Oh, yes, Mr. Nearbow, we'll have the page grab that from you. Thank you.
Thank you, sir.
All right, Mr. Chairman. So I'm going to try to attempt to address as many of those as I can. The first by confirming that, as Mr. Nearbout said, cows are milked year-round. There's no season for that, Mr. Chairman. So sorry, but there's no seasonal thing there. Let's go to the question. The first one was, who does this apply to? If you go to page 1, sublet 5, it's employers. We have that defined as what employers are. So if you're hiring a kid to mow your lawn or shovel your driveway, that doesn't apply. This bill is for employers, and that's what you're seeing implemented across the country. Social security cards, Mr. Chairman, one of the things that you were saying is it says on there not used as identification, but it is an actual item on an I-9 that you can use as a verification form, as well as passports, photo identification. So you can use a social security card on the form I-9. Biometrics was asked about. So the biometrics in this bill is about photo matching. So the system compares the photo on the employee's document, so take a green card, against the photo stored in the USCIS records. So that is what the biometrics is referring to. And there's limitations in this bill. So currently, E-Verify does not use direct physical biometrics like fingerprints. It relies on the information that is submitted on the I-9 form itself. So I wanted to address that and put that one to bed. Large general contractors. So prior to this session starting, I was asked to go meet with a very large general contractor here in Ada County, and they requested that we bring E-Verify forward. And it was very shocking to me that the construction industry would be requesting such a thing. What they're saying is unfair bidding is happening, where they voluntarily are using E-Verify at their company, and they said that the competition is not. And so their numbers are coming in substantially lower than theirs when they're running background checked workers versus the other general contractors are not doing that. So this was actually supported by a certain very large contractor here in Ada County. Testimony, Scar, I might get the last name, Rulian, was talking about how this is a big cost. It's actually not. E-Verify is free. So there's not going to be a cost for them to go and sign up for E-Verify. Nixon Matthews on page 4, line 4, Nixon was talking about how this is going to, I'm going to quote what it actually says here, a petition that alleges a violation on the basis of national origin, ethnicity, or race shall be considered invalid. So this is not about race. This has nothing to do with any of those things. So I wanted to make sure that we covered that that's right there in the language. Tim O'Donnell was talking a little bit about the support of the caucus. This has been a priority in our caucus, not only last year, but this year it made the list again in the survey in the caucus. But I will also note that over 80% of Idaho voters are in support of what we're doing here. So this is a very, very big winning issue here across the state. As far as the start date, I was talking to my co-sponsor, Representative Redmond. We are open to general orders if we need to change the start date. We're amenable to that. That's not for us like it has to be July 1st. We can work on that date. That's fine. But what this is good policy for the state of Idaho. As far as the things that were brought up recently about can anyone just bring a petition forward? Yes, it does say that. If you start on the bottom of page 3 and go into page 4, it does say that any resident of this state may petition, but there are things in there that are requirements for a valid petition, and there's things that are making it an invalid petition, and the Attorney General, he retains broad authority to throw out what he would call a frivolous claim. So all of that is standard language. So I'll let Representative Redmond close with some points that he's got.
Thank you, Mr. Chairman and committee, and thank you, Representative Crane, for answering some of those questions. I think it's been a very interesting debate here in this full hearing. I think we've had a lot of good insight and input and some really good questions from the committee. I want to focus again on what this bill does do. I think this bill protects Idaho's economy and its workers. The ones here legally, this protects our economy. It sets a level playing field for all employers. It does align with federal law and national security. It's not burdensome on employers. Again, we all have been e-verified. I think that, some of what we heard today about, the I-9s, this is the verification method that we need to have, right? We need to have accountability within government, and I think that's exactly what this bill seeks to do. And so, Mr. Chairman, I would ask, and again, if we need to make some adjustments, I think we're more than happy, within reason, I guess, right? But we would ask that you would send House Bill 704 to the floor with a due pass recommendation. Thank you, Mr. Chairman.
Okay, committee, we do have House Bill 704 properly before us. Representative Harris.
Yeah, thank you, Mr. Chairman. I move that we move House Bill 704 to the floor with a due pass, and I'd like to speak to that motion.
You may speak to the motion.
This is a common sense bill for the state of Idaho. This is what everybody in the state, 80% of the state, is asking for this. They want the accountability. Most of us are in these positions as elected officials because we are expected to hold people accountable to the laws of the state of Idaho and to speak for the people that live within this state. And that's what we're doing with this legislation. Arguably, one of the largest people that will be affected by this bill is the Dairy Association, and they just testified that they're not knowingly hiring illegal immigrants. I don't see the need to push the date back, because if they're not breaking the law now, then what do they have to worry about? I say let's send this thing up there, let's get it done, and let's move forward. Thanks.
Representative Cheatham.
Thank you, Mr. Chairman. This one's kind of a tough one for me. My district in southeast Idaho, we rely pretty heavily on not year-round labor, people who come and go, and they work in the various ag sectors. But to me, immigration is a federal issue. And if we're going to solve it, and I agree we've had an immigration issue the last few years, but I understand since the presidential order has changed in the last year and a half, most of that issue has gone away. We no longer have the pressure on the border. And I feel a little bit like we're trying to solve a problem that's probably going to go away on its own. When I first moved to Idaho 48 years ago, my wife was working at one business. I had a business to run, and we had a young kid, 3 years old. And we found a family, and I frankly do not remember how we found them, who babysat that kid while we were at work. And I don't know if they were immigrants or not. They had a Hispanic last name. Could have been. I don't know if they were residents or citizens of the United States at that time. But they did a fantastic job of working for us. We had another daughter. She went there for 3 or 4 years before she started school. And they were like second family to her. and they did a fantastic job of helping us raise our kids. Despite the evidence that's been submitted today, I kind of feel like the effect that a bill like this is going to have on particularly Franklin and Power counties in my district will be devastating. It will shut businesses down. We've already had one business begin to lay people off because of the problem in the ag industry. There's no margin left for those folks. They are going out of business left and right. And I just don't, I don't see how, if I'm going to represent my district, I can support this bill. Thank you.
Representative Thompson.
Thank you, Mr. Chairman. I have a sister-in-law that moved here from Mexico, and she came here legally. It was not a difficult process, and she's very happy she did. She doesn't have to renew her green card for 10 years. Well, it's probably 5 years at this point because she's been here for 5 years. But she went through the process. And like the one gentleman that testified, yeah, it could be a little arduous with the health and inoculations and the questionnaires and stuff like that, but she did it. She can't hardly speak English, but she's here legally. And I think that all we're doing is asking for due diligence for employees or those people that are wanting to work in the United States to be here legally. It can be done, and I will be in favor of this bill.
Okay. If I could just comment a bit myself, I don't see any other lights, so I'll take that privilege. I do have a couple concerns myself still, some raised even by the questioning and testimony today in committee. I think it's not possible for us to really contend that there will be no cost to the implementation of this program because we have a large general contractor telling us that they're losing bids because they e-verify voluntarily. And if a contractor tells you something about his price, then there is a cost to it. I'm also a little concerned still about the implementation timeline, which Representative Crane 13 raised. And so as I think about it, I think this is the direction that the citizens of Idaho want us to go. I'd like to make sure that we get it right and dial in these details. And so I would like to offer a substitute motion to send House Bill 704.
Unfortunately, that's out of order.
All right.
When you're chairing, you can't make a motion or second a motion. I'm sorry. I hate to.
Thank you, Representative Crane 13. It was worth a shot. Anyway, so I think for that reason, I'm not comfortable with it going to the floor as is. So, Representative Cheatham.
Thank you, Mr. Chairman. Let me finish your thought. Mr. Chairman, I move to send House Bill 704 to general orders.
Okay, Mr. Committee, we do have a proper motion, substitute motion before us to send House Bill 704 to general orders. Any further discussion or questions on the motion?
Mr. Chair, just ask for a roll call vote, please.
Okay, thank you, Representative Harris. There'll be a roll call vote. So again, the substitute motion is to send House Bill 704 to general orders. And
Is it too late for me to weigh in?
well, since the secretary looks like she's doing some things, Representative Cannon, go ahead.
Thank you. I'm just going to indicate that I'm going to support the substitute motion, and I'm going to do that based on what I perceive to be the sponsor's willingness to look at some issues in general orders. Thank you.
Okay. Thank you, Representative Cannon. Representative Crane 13?
Yeah, Mr. Chairman, before we vote, could I ask the sponsor of the bill, Representative Redmond, a question?
Question still in order, it appears.
Thank you, Mr. Chairman, and Representative Redmond. So are you okay sending the bill? What would be your preference? To send to general orders or to send as is?
Thank you, Mr. Chairman and Representative Crane. I mean, ideally, send as is. However, we would support it if it was going to fail. So I think very fine with my colleague there. If it's going to fail, we'd send it to general orders, knowing that really the only input we'd be looking at is the implementation date. We believe the bill is properly written, but the implementation date would be the only thing I think we would want to look at.
Follow up?
Follow up.
Thank you, Mr. Chairman.
Representative Crane to the most honest answer yet.
Well, that's always if it's going to fail, send it to general. Let me ask you this. If we send it as is and we get up there like we were wont to do today on a bill or enough people come to you on the floor and say, hey, I would move it to general orders, would you be amenable up there if it's a due pass to go to general orders if there's some issues pointed out?
Chairman Redmond.
Thank you, Mr. Chairman, and Representative Crane. That would be my preference. Yes, send it as a due pass, and then if enough folks came to us and had some good examples, we'd make those changes.
Okay. Then, Mr. Chairman, I will probably debate against the substitute motion because of the sponsor's willingness to work with it if there is a problem, but their desire to send it as is. So I will support the original motion.
Okay. Representative Birch.
Thank you, Mr. Chairman. I will support the substitute motion. And I would, and I think that there may be some other things in this bill other than an implementation date that people may want to talk about that I'm not sure really would be well suited for debate on the House floor. And I'd rather see discussed in advance before any vote might come before the House floor. One of the things that I'm concerned about, there being absolutely no penalty for making baseless claims. I mean, this legislature puts incredible penalties on just about everything, you know, when people don't do something they want them to do. So I think that there needs to be, I think considering some checks and balances on people making baseless claims that can really hinder businesses and bog them down. Even if the Attorney General determines they're not valid, he still has to do an investigation to determine that. So I would support the substitute motion to consider other aspects as well if this is going to become law.
Okay. Representative Razor.
Thank you, Mr. Chairman. I would like us to note that Idaho has robust statutes already dealing with false reports in Title 18, 5400. So that's already covered. And because of the willingness of the sponsors to work on the floor, I will be supporting the original motion as well.
Okay. All right. Thank you, Representative Razor.
Mr. Chairman.
Representative Barbieri.
Thank you, Mr. Chairman. I don't like the idea of having an extra step in hiring an employee, but I'm still going to support the original motion and vote against the substitute motion.
Representative Birch.
I'm not confident that there's existing statute that somehow imposes penalties on people for making false claims. I would want, in fact, to have the time to better understand that and what those penalties are, because the idea is to be a deterrence for making false claims, and it has to be significant. So I'm not confident that point of debate is completely solves that issue.
Okay. Thank you, Representative Birch. Okay. Seeing no further comments or questions, the Secretary will take a roll call vote.
Chairman Redmond.
I'm restating the motion on recommendation of experienced legislators. The motion is to send House Bill 704 to general orders. Go ahead, Michelle.
Chairman Redmond.
No.
Vice Chairman Wheeler.
Yes.
Representative Crane 13.
No.
Representative Palmer.
No.
Representative Barbieri.
No.
Representative Cornelis.
Yes.
Representative Crane 12.
No.
Representative Ehlers. Representative Monks.
No.
Representative Cannon.
Yes.
Representative Harris. Representative Marmon.
No.
Representative Razor.
No.
Representative Thompson.
No.
Representative Cheatham.
Yes.
Representative Veely.
Yes.
Representative Birch.
Yes.
Representative Green.
Okay, the motion fails 11-7. So committee, we now have before us the original motion to send House Bill 704 to the floor with a due pass recommendation. Representative Cannon.
Is there time to have discussion still on this or not?
I believe that would be in order. Go ahead,
Thank
Representative
you.
Cannon.
I just want to indicate for the record that I'm going to support this motion today, but I'm still doing a deep dive on this, and I reserve my right to vote whatever way my conscience dictates on the House floor.
Okay, your conscience will be noted. Representative Thompson.
I request a roll call vote, please.
Okay, we'll have a roll call vote. Representative Cheatham.
Thank you, Mr. Chairman. I'm going to follow Representative Cannon's lead and reserve my right to make a final decision on the floor.
Okay, Representative Birch?
I just want to confirm there's no opportunity to make any additional motions. Is that correct?
I believe that would no longer be in order, Representative Birch.
Okay, just want to double check. What, if I may comment?
You may.
Given the fact that it was discussed that we could do this on, on general orders and from the House floor, I would just make as a comment, it might have been more appropriate, and I should have thought of it to bring it to the floor with no recommendation. But I'll let that lie. Thank you.
Okay, your comment will be noted. Okay, I see no further comments. Not to fall into like the Rule 80 trend, but I think I will also follow Representative Cannon and Representative Cheatham's lead on this and reserve my right to change my vote on the floor. Okay, if no further comments, the Secretary will take a roll.
Chairman Redmond,
Yes.
Vice Chairman Wheeler,
Yes.
Representative Crane 13. Yes. Representative Palmer. Representative Barbieri. Yes. Representative Cornelis.
Yes.
Representative Crane 12.
Yes.
Representative Ehlers.
Yes.
Representative Monks.
Yes.
Representative Cannon.
Yes.
Representative Harris. Yes. Representative Marmon.
Yes.
Representative Razor.
Yes.
Representative Thompson. Yes. Representative Cheatham.
Yes.
Representative Veely. Yes. Representative Birch. No. Representative Green.
Okay, the House Bill 704 is sent to the floor with a due pass recommendation on a vote of 16-2. I will now turn the gavel over to our Chairman Redmond.
Thank you, Mr. Vice Chair, and thank you for all your work there. Next up on the agenda, we have House Bill 700. Representative Harris, if you could introduce yourself for the record and begin with your bill.
Thank you, Mr. Chair, members of the committee. My name is Kyle Harris, District 7, which is most of Nez Perce, Adams, and Idaho County. Today before you is House Bill 700. House Bill 700 creates some criminal penalties if you knowingly hire illegal immigrants. It also waives that liability if you do use the E-Verify process. Polling indicates that an increasing majority of Americans want to see employers who rely on illegal alien labor punished for using that labor. Federal law already prohibits employers from employing individuals who are unlawfully present in the United States or who lack work authorization. This adds no further administrative burden on employees. As we've all just discussed previously, E-Verify is not hard to use. So as long as you're using that, all of these criminal liabilities fly right out the window. We've talked about states like Arizona, but Florida, Tennessee, Texas, Missouri, these states have all implemented similar laws to this one here. And I would just ask for your due pass recommendation to send her to the floor.
Thank you, Representative Harris. Do we have any questions for Representative Harris? Representative Wheeler.
I do have a question, Mr. Chairman. Representative Harris, I'm just curious, as I read the bill, I think it's just right there below the fold on page 2, it does talk about this becomes a presumptive defense against prosecution if employers have depended upon the E-Verify system. I'm just sort of curious because we've heard some testimony that it is a somewhat flawed system. And so why are we going to grant sort of that near immunity to employers who are making use of a flawed federal system? Is that giving up some of our state sovereignty is sort of my concern.
Representative Harris.
Yeah, thank you, Mr. Chair. Representative Wheeler, it's a great question. I don't, you hear different people report flaws in E-Verify differently. I don't know if it's as flawed as some people would lead you to believe that the system is. At the end of the day, we're just asking people to do their level best to try and not hire illegal immigrants within the state of Idaho. And using E-Verify is the best process we have to verify whether or not you are legally able to work within the United States.
Thank you, Representative. Any further questions? Seeing none, we do have a little bit of public testimony. Michael Angeletta, if you could come to the podium, introduce yourself for the record, and you will have 2 minutes.
Thank you, Chairman, members of the committee. My name is Michael Angeletta. I'm here on behalf of Secure Idaho. And as you heard, we're a grassroots organization focused on strengthening Idaho's sovereignty and upholding the rule of law. You previously heard a bill about compliance that this bill is about credibility, I'd say. Idaho law already says you cannot knowingly hire an unauthorized worker. HB 700 answers a very simple question. Do we mean it? This legislation does not create a new immigration system. It doesn't invent new standards. It aligns directly with federal law. It established that knowingly violating the law in Idaho carries consequences in Idaho. Some may ask whether this is duplicative of the verification bill that we just heard. It is not. HB 704 establishes a universal verification framework and enforcement structure, while this bill, HB 700, codifies the underlying prohibition itself in Idaho criminal law. One creates the compliance system, the other makes clear that violating the rule knowingly is a crime in the state. And importantly, this bill protects honest employers. If an employer verifies a worker through E-Verify in good faith and receives confirmation, they're shielded from criminal liability. That protection is written directly into the bill. So I'd say this bill draws a bright line. Good faith employers are protected, and knowing violators are accountable. A statute without enforcement is merely symbolic. If something's unlawful, it should simply be unlawful in practice. That is what this bill does. I respectfully ask for your support. Thank you.
Thank you for your testimony. Do we have any questions for Mr. Angeletta? Seeing none, thank you. Next up, we have Scott McDougall. Do we have a Scott McDougall here? Do we have overflow? Do we have overflow? All righty, we'll move on to the next testifier, Lydia Strong. If you could make your way to the podium, introduce yourself for the record, and begin with your testimony.
Thank you, Mr. Chair, members of the committee. My name is Lydia Strong. I'm for the 12th district. The HB 700 is for enforce what you are asking for, HB 704. I used to be a lawyer, criminal lawyer in Brazil, and I understand law. When you create a law, you must enforce the law, and that's what it's built for, enforce the law. Make people have a penalty while they are breaking the law. For this reason, I come here this committee and asking for each one, please pass this bill because it's making justice. That's the reason I come to the United States in the first place. Brazil become a tyrannical country. The reason I left Brazil, I know when the United States become as Brazil. For this, I stand for this country. I love the United States. I begin to love American law. I love American Constitution. And for this reason, I'm asking for each one over here, be just, vote in your conscience. People like me come legally, have stand and say, we make this country better, legally. So to be here, you must follow the law. No one is above the law. Thank you. Open for any questions.
Thank you for your testimony. Do we have any questions for Ms. Strong? Seeing none, thank you. Next up, we have Charles Strong. You could make your way to the podium, introduce yourself for the record, and begin with your testimony.
Mr. Chairman, committee, again, Charles Strong from Napa District 12. What I'm looking at here is employers that know what they're doing. It has been testified earlier that the Dairy Association said that, oh, we're not hiring anyone. We don't know of anyone that's illegal. But then how do they know that 70% of their employees are here illegally? I challenge that credibility of that statement. That is wrong. They need to follow the law. They need to be able to go through and use the E-Verify system. If they use E-Verify, great, they have that immunity. But we darn well know that there are employers out there, the big ones that are out there, that are knowingly hiring illegals. And you know that. How can you tolerate that? How can you tolerate knowing that these people are going out and hiring illegal aliens to work in our fields, to go through and work against the law? I remember a time that there was a statement a long time ago, I remember, that southern plantation owners said, how can we harvest the fields, pick our crops without low-cost labor? Isn't that just what this is all about? They're complaining that they're having to pay higher wages. Please, I urge you to hold them accountable for hiring illegal aliens in this country. If they're here lawfully, great, hire them. But we have to do something here in Idaho. We don't need to be waiting for the federal government to act. We must act ourselves. And I ask that as a citizen of this country, and I ask for your support of this bill. Thank you.
Thank you for your testimonies. Any questions? Seeing none. Next up, we have Carlos Vidales. If you can make your way to the podium, introduce yourself for the record, and begin with your testimony.
Mr. Chairman, thank you very much, and committee members. I appreciate the opportunity to speak to you second time today. Again, my name is Carlos Vidales, and I stand in support of HB 700. You know, the United States has an illegal immigration problem. The root cause is people that come in droves, uninvited. They pursue a better life. The goals are very commendable. You know, I'm one of them. But their methods are unacceptable. For most foreigners, being allowed to live and work in the United States is a gift of immeasurable value. It is for me. The problem is that we cannot give to everyone who asks. We would do great harm to our citizens, our children, and our grandchildren if we don't limit immigration to reasonable levels. Illegal immigrants keep coming because employers hire them. They would not come otherwise. Why obey laws when breaking them has no consequences? If illegal immigrants were a drug, the employers who hire them are the drug addicts. Businesses need to make a profit to thrive, but profits are much more difficult to achieve when your competitors hire illegal immigrants and you do not. Employers to hire illegal immigrants without consequences enjoy a competitive advantage over their peers who obey the law. In the end, it is not illegal immigrants who created the problem. The fault lies with the employers who create the market for illegal immigrant labor. And HB 700 directly addresses these employees. Please support HB 700. It can help level the playing field for law-abiding employers because it will encourage those employers addicted to illegal immigration labor to ditch the habit. So thank you very much. If you have any questions for me.
Thank you. Do we have any questions? Seeing none, thank you for your testimony. Tim O'Donnell, if you can make your way to the podium, introduce yourself for the record, and begin with your testimony.
Thank you, Mr. Chairman, committee. My name is Tim O'Donnell, representing Secure Idaho. I want to apologize for redundancy in what I'm saying with my colleague because we didn't compare notes beforehand. We support this bill. It's a violation of federal law to knowingly hire unauthorized aliens, yet it continues here in Idaho anyway. This bill aligns with federal law and gives Idaho a necessary tool to enforce violations of state employment regulations. We need to ensure that all businesses are competing on a level playing field and not favor those who are not playing by the rules. Thank you for your time and consideration.
Thank you. Any questions for Ms. O'Donnell? Seeing none. Last up, we have Nissa Nagal. If you can make your way to the podium, introduce yourself for the record, and begin with your testimony.
Hello, my name is Nissa Nagel. I said it wrong before because I'm a bit nervous. I'm here as a bookkeeper with more than 20 years' experience in business administration, and I'm against House Bill 700. At its core, this bill is seeking compliance with a carrot and a stick. It creates criminality for something that is already regulated by the federal government, and then dangles that you won't face charges if you use the system we tell you to use. In a program that has been showed to be flawed, I mentioned before, in a 10-year period, there was shown to be 130,000 documented errors. I cite that in my written testimony. E-Verify flaws lead to real consequences. And I thought of earlier, but ran out of time, that 17% of Arizona undocumented workers that were found with E-Verify, I wonder what percentage of that 17% were actually in error? And then what was the process that the employee and the employer had to go through to have that corrected? A lot of hiring takes months, and then the actual process of bringing someone on time into the office actually takes months, and then you go through the whole process of the onboarding. It's a long process. Finding a good employee is a big deal. Using E-Verify does add another burden to small business owners. On the website, it says to enroll, it's an 11-step process. You have to provide your EIN, and the website warns that you have to be really careful about answering the questions because errors cause delays. Again, we've talked about how long it takes to hire someone, and then you're adding more time to verify when you're already doing the I-9, which is a verification process. And it also does not protect employers from ICE raids. Glen Valley Foods in South Omaha last June, even though they're a company that complies with E-Verify, they still had an ICE raid and 100 of their employees were detained. So how can the system be flawless if 100 of their employees were detained and they comply with E-Verify? Again, I provided that citation. Adding threat of criminal penalty to small business owners with unnecessary regulatory burden seems at odds with our state that convened the DOGE task force to improve government efficiency and cost reduction.
Ms. Nagel, if you can wrap up, we're at time.
Thank you. I just would like to say, I want to remind everybody that we're talking about people, and to call them illegals is not very kind. These are human beings. Thank you.
Ms. Nagel, do we have any questions for Ms. Nagel? Okay, thank you for your testimony. That concludes our public testimony. If the sponsor would like to give us some closing discussion.
Yeah, thank you, Mr. Chair. Again, Kyle Harris, District 7. For one, this is not an E-Verify bill. This is just an enforcement mechanism, and it has a immunity if you use E-Verify. It's federally illegal for you to hire an illegal immigrant in the country, period. This gives criminal accountability to people that knowingly break the law in the state of Idaho. Okay, I am here for accountability. This bill is all about the accountability. If you're using E-Verify, you're free and clear. Sorry, you went through the process, no prosecution. But if you are knowingly breaking the law in the state of Idaho, it is our duty to charge these people with the crimes they are committing. Often we keep looking only at the economic impact from agriculture and construction and house cleaning. We're missing the whole other side of this argument, which is the state. You know, we had the Idaho Department of Corrections testify that they know of about 250 illegal immigrants in our prison system that cost us $8.7 million a year to house. Okay, these people are taking up housing when we have a housing crisis. They're taking up space that could be open to Idaho citizens and American citizens to have these opportunities to live in these homes. They're taking over school space for Idaho children to go to school and get the education that we owe them through our Constitution. So all I'm asking for is the simple accountability to charge the people that are knowingly committing a crime with that crime. So with that, I would ask for your due pass. Thank you.
Thank you, Representative. Do we have any questions for Representative Cannon?
Thank you, Mr. Chairman. Representative Harris, how do you envision that the enforcement would work? This would fall under the jurisdiction of local sheriffs, is that true? And would they just go out and, as part of their routine, check into local employers to make sure they were following the law? Or in your vision of this, would they wait and get a tip that somebody was violating the law and then go investigate? Or speak to that if you would.
Representative Harris.
Yeah, thank you, Mr. Chair. Representative Ken, that's a great question. You know, I don't think any sheriff would just start poking around businesses saying, hey, show me your documentation on your employees. I think it would come down to more of a tip line situation to where somebody's going to report, hey, these guys are hiring some illegal immigrants. Maybe you should go investigate that. And then if they do the investigation, they find out you used E-Verify, then that complaint would go away. If not, then you're knowingly hiring and employing an illegal immigrant, and that's where the enforcement would come in.
Follow-up?
Follow-up, if I may. So I'm just looking at your fiscal note, and it indicates that no additional expenditure of funds is anticipated at the state or local level of government. Therefore, this legislation has no fiscal impact. If the local sheriff's departments are investigating and so forth, it would seem to me like there would be an additional burden on our local sheriff's departments, and I'm wondering if you're just anticipating that that would just be borne by the existing labor force in the law enforcement, or if you feel like there are additional manpower needs that would be required in order to enforce this.
Representative Harris. Yeah, thank you, Mr. Chair. Representative Gann, I don't think you need to add any more law enforcement to enforce the laws that we have in this state. We have a habit of passing legislation that adds new mandatory minimums and creates new crimes. Seems almost every other day in this building. Law enforcement is charged with enforcing laws of the state of Idaho, so I don't necessarily see us needing to build a whole new task force or, hire a bunch of new staff to go deal with this issue. It's a simple thing of you commit a crime, you get charged with your crime, you go through the prosecution process, and you're either guilty or you're innocent, and then the steps move forward. So I think this would just continue to operate within the normal regulation of laws in the state of Idaho.
Representative Wheeler.
Thank you. Representative Harris, would you just walk through for me, how is this going to interact with the supremacy clause? If we are essentially granting immunity or whatever the phrase is here, the defense for breaking a federal law, and an employer depends on that immunity by using E-Verify, and then the feds say, no, you're still breaking federal law, and what kind of situation can that put these potential employers in? Help me understand that interaction.
Representative Harris.
Yeah, thank you, Mr. Chair. Representative Wheeler, it's a really good question. I don't know if the supremacy clause would invoke here. I think federally, if you use E-Verify, I don't think you can be held accountable. And at the federal level, I'd have to research. I don't know. I'm just snowballing off the top of my brain here. But I think you are exempt if you use E-Verify, even at the federal level. I could be wrong. But at the end of the day, this would be a state law. So we're just enforcing state law. It's not an immigration law. It's just a law saying that if you are knowingly breaking a law, that we're going to charge you with a crime in Idaho.
Representative Cheatham.
Thank you, Mr. Chairman. Representative Harris. If it's a federal law, why do we need this?
Representative Harris.
Thank you, Mr. Chair. That's another good question, Representative Cheatham. Because the federal law is not being enforced in Idaho. We have illegal immigrants working everywhere, and we have sheriffs that are not signing on to the 257G program, which allows them to hold these people accountable, the immigrants themselves, right? So right now, nobody's doing anything to enforce the law. So by creating a law, we have our own enforcement mechanism to actually hold businesses in Idaho accountable, which should stop the spread of illegal immigrants migrating into this state because they have nothing to come here for.
Follow up?
Yes, follow up. Thank you, Mr. Chairman, Mr. Harris. But sheriffs can enforce federal law, can't they? If they so choose. What are we doing here to reinvigorate the statute?
Representative Harris.
Thank you, Mr. Chair. Back up from my co-sponsor on this legislation. Sheriffs cannot enforce federal law. They don't have that authority. They have authority to enforce state law. So the only people that you'd have to bring in Homeland Security or somebody else to start enforcing those laws within the state of Idaho.
Committee, do we have any other questions? Maybe Representative Green?
Thank you, Chairman. I was going to give somebody else an opportunity to ask questions. But,
Okay.
thank you, Chairman and Representative Harris. So curious, your idea is that we're going to set up a tip line and people can rat out whomever they like about whether or not they feel like they're breaking the law. Like, what would be the grounds of them calling that tip into law enforcement? Because I can guarantee you my husband has a lot more to do than chase down tips about somebody of a different race walking into a business next door. So can you help me understand what that's going to look like?
Representative Harris.
Yeah, thank you, Mr. Chair. Representative Green, great question. I'm not envisioning necessarily a tip line. The enforcement of this law will come down to prosecutors and law enforcement on how they want to go out and deal with this situation. I would like to note that immigration doesn't specifically talk about people of color. There are lots of white people that immigrate to the United States, some illegally. So I try to keep race out of it as much as possible. At the end of the day, this is no different than any other law that's enforced, right? If you're going to be driving down the road without driver's license, they're not running your license plate to see if you have a driver's license, right? You have to get stopped to find out if you have a driver's license. So there has to be some, I would assume, I'm not a law enforcement officer, but I would assume there would be some steps that you would take to get you to that level of saying, oh, wait, there's potentially a crime here, we should investigate that crime.
Follow up?
Yes, thank you, Chairman. And Representative Harris, can you give me an example of another law where the sheriff's department or our law enforcement officers are policing business? Is there another example you can give me where there's a law that they would go out and police the business for?
Representative Harris.
Yeah, thank you, Mr. Chair. Representative Green, we have ABC laws where they police whether or not you have a lockable cabinet behind your bar. There's tons of laws pertaining to business that law enforcement is specifically involved in. We have health districts that go in and police the health standards of the restaurant and the kitchens and the bathrooms. This isn't necessarily going in and physically policing a business. It's just holding somebody accountable if they're caught breaking the law.
Committee, any further questions? Not seeing any. Committee, we do have House Bill 700 properly before me. Representative Razor.
Mr. Chairman, I move that we send House Bill 700 to the floor with a due pass recommendation.
Thank you, Representative. We do have a motion to move House Bill 700 to the floor with a due pass recommendation. Any discussion on the motion? Seeing none, all those in favor signify by saying aye. Aye. Any opposed? Nay. Do you wish to be recorded? So Wheeler, Green, and Birch. Okay. He doesn't want to be recorded. All right. Thank you. Last up on our agenda, we have House Bill 645. Representative Monks, if you can introduce yourself for the record and begin with your bill.
Stop wasn't on me this time. I just wanted to know.
I was like, we gotta finish it, you know what I mean? And I thought they were here for 6:45.
I did too, Mr. Chairman. I feel kind of bad now that everybody just walked out and left me. Maybe that's good. Mr. Chairman, committee, I will try to be respectful for your time here. Been here a bit. About 30% of our American workforce has a different relationship than most, and they work as independent contractors. And especially with our gig employees, you're seeing that much more as a preferred way of working, where people have a lot more freedom in how they set their schedules and how they work and who they work for. And you'll see them, they work for multiple different companies, whether it's Lyft or Uber or Uber Eats or whatever they want to do. But what that causes, though, is those individuals don't usually have benefits that are available to other people. They don't have health care oftentimes, or at least they don't have one that's a company-sponsored one. Retirement plans, disability plans as well. This legislation will provide a mechanism where they can, if they so choose to do so. This is a completely voluntary plan. We are dealing with voluntary portable benefits. So what it is, it's a very simple arrangement between an employer and a 1099 contractor. So if a 1099 contractor wants to have that as part of their benefit package, they can do it. The reason they can't do it right now is because once you start offering some sort of benefit to them besides just a contractual amount that you agreed upon, then they're starting to look at that employee-employer relationship, and then we run into problems that way. This just sets some clear language that if you do have one of those, it's a voluntary program, and it would not necessitate or require that they become subject to that employee-employer relationship. I do have an expert here, Ms. Justan Rice, that if I need to, I will phone a friend if you have questions that I can't quite answer. But I do want to make sure I point out some of just the real important things here. This is voluntary. Nobody has to do it. It's got to be an agreement between that employer and the 1099 employee. And it doesn't affect any existing employees, doesn't affect any existing benefits that are out there. And one of the benefits is this does encourage people who are 1099 employees to get some of those benefits that would be available through health insurance, through retirement plans. These are all good things that we want them to have, and this allows them to do that. With that, I'll be quiet now. I see some lights already.
Thank you, Representative. Representative Palmer.
Mr. Chairman, is there anybody signed up to
Yes,
testify
we
against
have.
this?
I'm sorry?
Is there anybody signed up to testify against the bill?
Yes, we have 2 signed up to testify against. Going to be an early motion. Representative Wheeler.
Representative Monks, I'm just curious, seeing committee, do I need to ask for permission to refer to pending legislation? Just trying to keep a theme here. Would an employer under House Bill 704 have to use E-Verify if they had a 1099 relationship like this?
Representative Monks.
Thank you. Representative Wheeler, Chairman Redmond, 1099 employees, in my understanding, don't have to, but that's not my bill. I'm not the expert on 704 or 700, so I would suggest that you ask the sponsors of those legislation.
Follow-up.
Follow-up.
All right, I'll try for one that may be more in your expertise. Is there any specific sort of bank account or receiving account that a 1099 employee would have to have set up to receive these benefits? Does that change that nature at all?
Representative Monks.
Thank you, Chairman. Representative Wheeler. If you're on page 2 there, if you talk about how it's administered, it's pretty simple, and it just says any person or entity, whether public or private, may voluntarily contribute funds to a boardable benefits account for an independent contractor. And so that would be something that would have to be agreed upon by the employer and the independent contractor as far as to find out how they want to set up that funds for them to donate to that particular thing. Again, a 1099 employee, they do have to have essentially a W-9, which they're filling out. And so they are attesting whether or not they're legal. Also, banks do have requirements as far as if you're looking at the illegal aliens. Again, we're not trying to deal with anything here. There's plenty of other laws dealing with that. We're not trying to touch or adjust any of that at this particular point. But there are plenty of laws in place that would prohibit that anyway. And you can, as a employer, hire a foreign company if you want. You can hire them if you want. There's actually a W-8BEN or a W-8BENE if it's an entity versus an individual. So a legal resident here who's has a work visa or whatever else, they can be 1099 employees, and there's a process for that. And those are the forms that they would have to have in order to be able to receive these types of benefits.
Thank you, Representative. Representative Harris.
Yeah, thank you, Mr. Chair. Representative Mux, just so I can get a very base understanding of what the concept of this legislation is. So what you're suggesting is, let's stay in like the realm of construction. A general contractor would hire an electrician as a 1099 sub, right? The general, if this passes, the general would be able to offer a retirement benefit, a healthcare plan, something like that, without bridging the line that says now you are an employee of mine, correct?
Representative.
Chairman and Representative Harris, yes. However, I would just clarify, though, this doesn't change that definitions of what an employee-employer is. This just says, if you do those things, we're not going to change the definitions. So if they are the only employee working for that company, and it can be demonstrated that they are truly an employee, then we're not touching that.
Thank you. Any further questions? All righty, we'll start with the public testimony. Thank you, Representative Monks. We have, I believe it's Justan Rice. You could please make your way to the podium, introduce yourself for the record, and begin with your testimony.
Of course.
Mr. Chair, members of the committee, my name is Justin Rice, and we can all collectively just blame my parents for the weird name, the pronunciation, the whole 9 yards. Anyway, thank you for having me here today. I represent the Libertas Institute. We are headquartered in Salt Lake City, Utah. And just for a little bit of background, I did want to let you know that the Libertas Institute actually was the primary architect of this model language, which passed in Utah unanimously in 2023. Since then, we've had a few more states that have jumped on the bandwagon for portable benefits. And so far that we've also had a great deal of support for those benefits. So without further ado, the reality of work in Idaho and across America has fundamentally changed. Hundreds of thousands of Idahoans earn income as independent contractors, driving, delivering, consulting, building, and creating. They value the flexibility and autonomy that comes with that work. But too often they face a painful trade-off. Independence in exchange for the benefits that help them manage risk and plan for the future. HB 645 solves that problem without mandates, without bureaucracy, and without reclassifying workers. It simply creates a legal framework that allows hiring parties to voluntarily contribute to portable benefit accounts owned by the contractors. The benefits follow the worker, not the job. Critically, the bill is explicit that these contributions cannot be used as evidence of employment status, as Representative Monk spoke to. That protection is essential. It removes a legal barrier that has prevented many companies from offering this kind of support in the first place. The tax provisions further strengthen the incentives. Deductions for hiring parties and income exclusions for contractors create a genuine win-win. With that, we urge you to vote in favor of HB 645.
Thank you, Ms. Rice. Do we have any questions for Ms. Rice? Representative Cannon.
Thank you, Mr. Chairman. Ms. Rice. So contractors can have a contractual relationship with lots of different companies and so forth. Where this is played out in Utah and or other states, are there scenarios where you've got these portable plans with a contractor that has in essence multiple portable plans with different entities with whom they have a contractual relationship, and how does that play out? Is it super complicated or is it pretty easy?
Sure. Mr. Chairman, Representative Cannon, thank you for your question. The answer to that is that yes, independent contractors can have work with different entities that can voluntarily provide them with contributions to their portable benefits account. It's actually quite simple, while it may sound overly complicated to be certain. The one thing that's really important here is that one is voluntary for the hiring entity as well as for the independent contractor. The portable benefits account belongs to the contractor. So what that means is that it could be a banking institution, it could be a different platform. I'm going to give you an example that there are actually 2 platforms that provide portable benefit accounts specifically for this very reason. One of them is Stride Health, the other is called Rocket Med. And so what this does, it allows for the contractor to go out and seek a portable benefits account from whatever entity institution may be offering those things. So once they have that account, then when they go to contract with an entity, this can be part of that contract negotiation. Is to say, look, I have a portable benefits account. If you would like to contribute to the portable benefits account, we can certainly do that. Now, this might be a withholding from the income of the independent contractor. They can certainly make that arrangement to say, if I'm paid $200 a week, would you please put $150 into my portable benefits account and then $50 into my bank account? So there is a great deal of flexibility here. The thing too is that, sorry, I'm being long-winded here, I just want to make sure I'm thorough, is that when a contract ends, so if an independent contractor chooses to no longer work for, let's say, Lyft or Uber or DoorDash, that they have the opportunity to keep that portable benefits account. It follows them. So they're not losing that opportunity. Like I said, it follows the worker, not the hiring entity. I hope that answers your question.
Thank you.
Representative Cheatham.
Thank you, Mr. Chairman. Ms. Rice, are there tax implications of these portable benefit accounts for employer or employee?
Ms. Rice.
Mr. Mr. Chair, Representative Cheatham. What this does actually provide a tax benefit. So what this does is it actually follows what benefit structures are typically seen within typical employment situations. So any contribution that is made by the entity, 100% of that can be written off as a business expense. When it comes to the contractor, the 100% of those contributions are not reported on their income. So that is where there's sort of a mutual win-win here, one for the hiring entity as well as for the independent contractor.
Representative Barbier.
Thank you, Mr. Chairman. Ms. Rice, I'm curious about lapses in employment. Do these policies lapse after a certain amount of time, or how does it work in terms of making sure that there is a constant contribution?
Ms. Rice.
Of course, Mr. Chairman, Representative Barbieri. What this does is it's a completely voluntary both ways. So like I said, if an entity decides that they're not going to contribute to that account, that is no problem at all. That's just not within the contractual obligation between the entity and the contractor. Now, what happens is that when contributions are made to a portable benefits account, is that that employee, or that independent contractor has the opportunity to opt in to whatever plans that they wish. So that might be for healthcare, that might be for retirement, that might be any number of savings, any number of things. So they would follow that same trajectory as a typical employee, where there would be an open enrollment period, but this would all be handled under whatever selections they make based on the insurance that they're choosing to utilize to their portable benefits account.
Follow up?
So now I'm starting to get the picture here. So the contributions to the account from that account are made the payments to the insurance company or whoever's covering it. So it's not like it's directly to the insurance company. It's going into the benefits account, and the contractor draws from that to make sure that the payments are made on a regular basis.
Ms. Rice.
Mr. Chair, Representative Barbieri, that is absolutely correct.
Committee, do we have any further questions? Seeing none, thank you for your testimony.
Thank you so much for having me.
Yeah. Next up, we have Gil Aroset. Hi. Sorry, I couldn't quite read it. Please introduce yourself for the record and begin with your testimony.
Mr. Chair, members of the committee, you enunciated that perfect, so thank you. My name is Gil Aroset, and I'm a representative with the Western States Regional Council of Carpenters. We represent over 1,400 members in southern Idaho. And I had a speech. I'm going to kind of throw it out the window because I didn't anticipate listening to 700 and 704 prior to this, and we lost all our audience here. But here's the thing, is I think that those bills kind of work hand in hand on here with this bill. And here's why. Where our contractors privately bargain to better the working conditions, benefits, and skilled and portable benefits, union multi-employer pension plans, we're all for that. But I'm against 645. And here's why. You guys voted on 700 and 704. I'll tell you something. In the construction industry, we see the largest cases of misclassification of workers as independent contractors when they are not under the DOL, under workers' comp, and under Idaho Tax Commission, which all follow federal law, right? This would open up an avenue to exploitation. If in the back door, you're trying to create enforcement with E-Verify, right? And there's no mechanism in regards to verifying independent contractors, right, for E-Verify, which is already a large exploitation in the construction industry. We see on publicly funded jobs, second and third tier contractors hiring other contractors, which then classify those workers as independent contractors to pay them cash under the table on publicly funded jobs. This would allow an avenue for contractors to hire, which a lot of times we see this misclassification happen to undocumented workers. I'm not here to speak on behalf of 700, 704. What I am trying to say is if you are for 700 and 704, that would just streamline and open up a can of worms to allow this exploitation to run rampant, which is already a pandemic. So I am against this. And like I said, I'm not against portable benefits for independent contractors, there's just no language here that clearly talks about misclassification and the worker and independent contractor definition. And this would just open up an avenue. I opened it up for questions if you may have some.
Thank you for your testimony. Committee, do we have any, Representative Crane 13?
Thank you, Mr. Chairman. Sir, I'm trying to figure out, why would you not want an employee to have benefits?
We're not talking about employee. This is talking about independent contractors.
Follow up?
Thank you, Mr. Chairman. And sir, why wouldn't you want an independent contractor to have benefits?
That's
Mr. Absett.
and that's not what I'm speaking about. I'm not speaking about independent contractors having that. I'm speaking about this language. To me, there's no language here, and with the language of 700 and 704, it would open up an avenue for more exploitation. I'm not opposed to a Lyft driver having a portable benefit, but there's no language here that actually is going to stop that misclassification or defines that clearly. And if there's no enforcement mechanism as far as e-verifying this, what you guys were talking about earlier, independent contractors, and that would just, to me, open up an ability to exploit workers as independent contractors and misclassify them. That's what I'm speaking about.
Follow up?
Thank you, Mr. Chairman. Help me understand, how do they get misclassified? If you're an Uber driver, you're an Uber driver.
I'm speaking in construction standards, sir.
Mr. Arrowset?
Thank you.
Follow up.
Thank you. So you referenced an Uber driver. Now you're telling me it's construction. So let's go to construction then. Help me understand how someone gets misclassified if they're a drywall contractor. They're a drywall contractor. How are they getting misclassified? So help me understand where you're going there.
Mr. Arrowset?
Representative Crane, thank you. So I'll give you an example, and this just recently happened on a project. I don't want to defamate anybody or their character, but we just seen this on a public works project here in Boise. First tier subcontractor got awarded the job by low bid. They hire a second tier subcontractor. Those are a legitimate second tier subcontractor. The second tier subcontractor then classifies their workers as independent contractors, unregistered, unlicensed, no one's enforcing that, right, as independent contractors. So now you have 30 drywallers on a project that are misclassified as independent contractors, which is cash pay, right? They're not contractors by the Department of Labor or IRS, right? What I am saying is that this would open up an avenue to have that exploitation happen more often in the construction industry. Particularly, I'm speaking on behalf of carpenters because that's who I represent. That's who we see prevalent a lot in the construction industry is drywall. We see this happen a lot on drywall. I would encourage you guys to walk some multifamily projects because this happens all over the place where you'll see 50 independent contractors as drywallers that are not independent contractors. They get told what to do, right? They get told where to go by the Department of Labor and by IRS. They are already defined as workers, but they're being misclassified as independent contractors.
Follow up?
Yeah, thank you, Mr. Chairman. Just maybe for the edification of the committee, let's use the Capitol building as our example, as the Public Works project, okay? So help us understand what a tier 1 is and then a tier 2. You use some terms there that I've not heard before. So let's say that we're doing the Capitol building here. So walk me through that example using the Capitol building so you're not defaming anybody.
Okay, 100%.
Mr. Arrowset, sorry, just if you can go through the chair.
I'm sorry.
Yep, you're fine. Mr. Arrowset?
Sorry, I'm a little excited. Mr. Chair, Representative Crane, thank you. I apologize.
You're fine.
So an example under the Capitol, let's say that the Capitol had a remodel to do some, knock down these walls, redo the steel stud framing as well as the finish work, right? Contractor was awarded the exterior systems, which is drywall, steel stud framing, acoustical ceilings, right? That contractor is awarded by state statute low bid, right? They get the job. They then subcontract to a second tier subcontractor the drywall, right? So now that contractor that was awarded the steel studs, acoustical ceiling, and drywall, second tier subs it out to a drywall subcontractor. Now that subcontractor that is doing the drywall is misclassifying their workers as independent contractors. So now all of a sudden you have 30 drywallers hanging drywall on your job that aren't independent contractors. Does that make sense?
Follow up?
Thank you, Mr. Chairman. So I'm still a little confused. I understood all your example until it got to the drywallers being independent contractors. And why would you want those guys to have a portable benefit?
Mr. Arrowset?
What I'm saying is they're under IRS, and under Department of Labor standards, those are not independent contractors. We're talking two different things. In the classification of independent contractor, you have to be able to essentially, in the construction industry, you're getting told what to do, you're giving the resources. Those are all DOL standards. So that's already defined. Those workers are not independent contractors. You don't have 30 drywallers on a job hanging drywall by DOL, and here's the thing, there's another thing, there's a level of safety mechanism to that. When we're talking about workers' comp, when a lot of these workers are misclassified as independent contractors, then there's a liability. There's a liability in regards to workers' comp because a lot of times they're told, hey, go get a contractor registration. Like I said earlier, a lot of these workers are undocumented, so they don't know labor law. So they don't go out and get workers' comp, right? So at the end of the day, now we're having a safety liability on the project because these workers are hanging drywall. They think they're workers, but they're independent contractors, right? I'm speaking on behalf of misclassification. You don't have 30 drywallers independently classified under federal, state law for DOL or for the IRS code. That is not that is not in the construction industry. You're talking, I believe, of Uber drivers and Lyft, which is I'm not opposed to.
Representative Ehlers.
Thank you, Mr. Chairman. Mr. Adaros. So do you have the bill in front of you?
Mr. Arrowset.
I can pull it out.
Okay. Mr. Chairman, looking at page 1, line 24 gives the definition of an independent contractor, which to me matches the existing definition of independent contractor that we already have in state code and really lines up, I think, with the federal version of independent contractor. So is your concern just about the enforcement of the existing definition of independent contractor?
Mr. Arrowset.
Mr. Chair and Representative Ehlers. Ehlers, sorry, I apologize. What line item? Could you repeat what line item that was?
Representative Ehlers.
Yeah, Mr. Chair, page 1, line 24 and onward, 24 through 28.
Mr. Arrowset.
I guess I'm not reading where Mr. Chair and Mr. Ehlers, I wasn't reading where that is on here.
Representative Ehlers.
Yeah, Mr. Chairman, I'll try it again. Sorry, page 1.
Yep.
And then line 24. Maybe those don't have line numbers on them. It's midway through section 4. Says it gives the definitions, and it says independent contractor about the middle of the way through the page, page 1.
Mr. Arrowset.
Mr. Chair and Representative Ehlers, I see that line. What I would like to see is a little more stronger language. I don't think that's gonna, like I said earlier, I think that there's still avenues in this bill that would allow for that misclassification. It'd be nice to have some language that clearly states that the employer is gonna qualify the classification as a worker, as an independent contractor, not a worker.
Representative Veely.
Thank you, Mr. Chair. Mr. Chair said, I'm trying to understand what your concern is, and let me see if I can articulate what your concern is. Are you saying that this makes it more amenable for a worker to be classified as a contractor because that worker can still receive benefits versus saying, no, don't classify me as a contractor. I need to be an employee so I can receive benefits?
Mr. Arrowset.
Mr. Chairman, Representative Veely, no, what I'm saying is in conjunction with the other bills that were just read is I think what we're talking about here is we're talking about portable benefits with actual independent contractors. And what I'm stating is that if with the House Bill 700 and 704, we're creating an avenue of workers that are going to be undocumented now, that are going to be kind of left behind, and allow the ability in an industry that already misclassifies a lot of workers to be 1099 as independent contractors, and no one's verifying that under 700 or 704. So what I'm saying is this creating another avenue in a construction industry that already is prevalent in misclassification of workers.
Committee. Representative Harris.
Yeah, thank you, Mr. Chair. I think I'm going to take a stab at this one because I think I understand what he's saying now. So essentially what the argument is that I'm understanding you arguing at this point is that if we were to pass House Bill 700 and 704 all the way through this body, get signed into law, what he's suggesting is that industries like dairy, for example, would now classify all their employees as 1099 employees because then they can now get benefits through this legislation if this were to pass.
Mr. Arrowset, is that?
Are we
getting closer?
Mr. Chair and Mr. Harris, I think that we're probably a little far off on what I'm trying to articulate here. I apologize if I'm confusing the room a little more. I don't mean to talk about ag. I have no understanding of ag or any other industry. I can only speak on behalf of carpenters, which I represent, right? What I am saying, why I was referencing 700 and 704 is my understanding of those bills, then there would be a lot of undocumented workers. I don't know the enforcement. I didn't go into the weeds or details on what that would look like, but I do know that there is a lot of undocumented workers out there. What that would create a working pool of undocumented workers that now could potentially be misclassified in an industry that already misclassifies a lot of workers as independent contractors when they're not. Because when you have undocumented workers, a lot of times in the construction industry, that is the industry where we see a lot of misclassified undocumented workers. So what I am saying is, if you have the enforcement of 700 and 704, then you may potentially see a lot of those ag workers now come into the construction industry, and a contractor that may be a second tier subcontractor say, hey, I'll hire you as a 1099 subcontractor to come hang this drywall. And then there's no enforcement of the 700 or 704 on that independent contractor. Does that make sense?
I think we're there.
I hope that clarified. I'm sorry if I confused it.
Well, thank you for your testimony. Representative Crane 12.
Mr. Chairman, I'll take a stab at it.
All right, here we go.
I think he's saying that we should not advance 645 and 700 and 704 was the best bill he's heard. That's what I'm hearing.
Mr. Arrowset.
Mr. Chair, Representative Crane, I'm only here to speak on 645. I'm neutral on the other bills, but I appreciate that you understood what I was getting at there.
Thank you, Mr. Arrowset. Appreciate your testimony.
And Mr. Chair, I would say thank you. There was a lot of stabs here. I will go sit down.
Thank you. All right. Kenny Houston, if you could introduce yourself for the record and begin with your testimony.
Thank you, Mr. Chairman and members of the committee. I will also take a stab at this. For the record, my name is Kenny Houston, and I represent the Idaho State AFL-CIO and stand in opposition to House Bill 645 as written. So verifying legal immigration status is essential to protecting Idaho's workers. This legislature has demonstrated, especially this session, that legally accessing employment and its best benefits is a high priority for the state. And for more, I defer to the opening and closing testimony from you, Mr. Chairman, and you, Representative Crane 12, on House Bill 704. Worker misclassification is a widespread issue in the construction industry. Many individuals classified as independent contractors are performing work that legally qualifies them for employment status. But in those cases, work authorization would normally be would normally be verified, but there's no comparable verification process for 1099 contractors in law or in any pending legislation this year. As a result, misclassification has become a way to bypass standard employment requirements. This bill allows hiring entities to provide portable benefits to independent contractors without verifying work authorization or ensuring proper classification. It creates incentives to maintain 1099 status while offering employment-like benefits without employment-like accountability. It does not prioritize the protection of Idaho's authorized workforce. The Idaho AFL-CIO heavily backs the expansion of access to benefits, but only when safeguards exist to protect lawful employment and prevent misclassification. As written, this bill provides for benefits without verification of immigration status or accurate classification. We advocate for Idaho's workers and believe that jobs provide benefits, jobs that provide benefits should go to legal Idaho workers, not illegal immigrants. And for these reasons, we must oppose the bill in its current form. And with that, Mr. Chairman, I stand for questions.
Thank you, Mr. Houston. Committee, Representative Wheeler.
Thank you, Mr. Chairman. Mr. Houston, question. You sound like the statement you've made on a couple occasions is that as written, you oppose this bill. Could you share with us if there are some amendments or changes that would make this bill palatable from your perspective?
Mr. Houston.
Mr. Chairman and Representative Wheeler, I think that, the stated intent of this legislation is to provide portable benefit plan offerings exclusively to those gig economy workers. And that's something that, we are in firm support of. But, I think that with the broader issues of the current state of the construction industry, we're concerned that this is providing a pathway for employers to almost incentivize people who've been classified as 1099 to not report that they have been misclassified, because now they're receiving a contribution to this portable benefits plan, as opposed to just going and reporting that issue, being correctly classified, and receiving a whole suite of benefits, as opposed to what narrow sliver of that benefits pie, if you will.
Representative Harris.
Thank you, Mr. Chair. Mr. Houston, did I just hear you say, uh-oh?
You may have.
Mr. Chair, Mr. Houston, under the misclassification, I believe I already touched on it in the previous debate. Doesn't Idaho currently have strict classification laws, and don't we have agencies that enforce those laws? And if you're caught, wouldn't you be punished by committing fraud at that point, or defrauding the state of the employer-employee relationship and benefits and taxes and all the things that go along with that, which is why 1099 is separate? So how do you think this is going to affect the current laws that we have, and how do you think this would loosen any of the current laws that we currently have for that relationship?
Mr. Houston.
Mr. Chairman, Representative Harris, and I do apologize, Representative Wheeler, I don't think I touched on all of the proposed amendments that we might have. Representative Harris, you're absolutely correct. There are laws on the books that say what qualifies and what does not qualify as a 1099 employee. I think that one step that we think could go a world in improving this situation that we're seeing is if we included a provision that said something to the effect that either the employer or this independent contractor must certify with the Industrial Commission or with the Department of Labor that an employee, that this 1099 contractor does in fact qualify as a 1099 contractor before voluntary contributions to this portable benefit plan could start. I don't think that what we've seen in the construction world, the Department of Labor or the Industrial Commission do the best of jobs when it comes to investigating those cases where an employee has been misclassified, or rectifying those issues when those issues come to light.
Follow up?
Yeah, thank you, Mr. Chair. So just so I get a better understanding of the stance that your body is taking on this legislation, if this bill were to amend it to exclude, the benefit package for trades or construction and just kept it towards gig economy, Ubers and DoorDash, whatever drivers, would you guys still have the same stance, or would your stance be different?
Mr. Houston.
Mr. Chairman and Representative Harris, I don't think that, we have rectified the issue of there is no existing process for 1099 employees to be verified to be lawfully here. But that your suggestion may get our dog out of the fight, if you will.
Obviously, Mr. Claus in the previous 704 legislation that says an employer may not avoid liability under this section by contract.
Representative Veely, I do not believe it does. I think that 704 and 700 are exclusively related to the employee-employer relationship and does not apply to the independent.
Saying that if they're just going out directly, this is what you're saying.
Mr. Houston.
Mr. Chairman and Representative Veely, I believe that's correct. I think the language that I've seen, I can't remember which one of the verified bills it was, but it is exclusively applicable to that business entity. So if you have a subcontractor, the general contractor is not culpable for what the subcontractor does or does not do.
Follow up, Mr. Chairman. One more, Mr. Houston. So then what you're saying, and again, I'm seriously asking this, I'm just to see if I can articulate it correctly, is that this is going to incentivize a bunch of people who potentially lost their job, who could have been, maybe they are here illegally, they've left their employment because they know it might be coming down on them, and they just go and open up their own 1099s and start going around and working under 1099s?
Mr. Houston.
Mr. Chairman and Representative Veely, I think that's certainly a possibility. But in a similar vein, parallel to that situation happening, I think that there could be an issue with a subcontractor putting out a bid looking for workers on a job, and they just misclassify them as a 1099 employee as opposed to classifying them as a full employee. I think that is pretty common in the construction realm. Construction jobs are temporary by nature. And we see a lot of laborers and workers jumping from job site to job site. So I think those two things can happen in tandem.
Follow up.
Last one, Mr. Chairman. Is this really a first order effect of 645? I'm meaning, is this really 645 truly incentivizing this behavior, or is this just a couple paths down there that this could be seen as incentivizing it versus being a direct first order effect of it? I'm thinking 645 benefit, in my eyes, still somewhat outweighs the downsides that we could see here.
Mr. Houston.
Mr. Chairman and Representative Veely, I think that we would potentially see direct effects of, perhaps a rampant behavior of Miss 645, though I do not think that we would absolve the issues and I think that's why we come to testify today. We're looking for amendments to be made to get this right, as opposed to revisiting at a later date.
Didn't see no further questions. Thank you for your testimony.
Thank you.
We have one, Heather Andrews. Yep. Looks like maybe.
I wonder if we would have had similar discussions had different bills not been heard ahead of time. But I would say this, we have rules very clearly saying we do not refer to pending legislation when we're discussing a bill. These bills stand alone. This is a standalone bill. I care less what House Bill 704, 700 does. I only refer to that because we've been talking about it all hearing long, which we are not supposed to. Let's look at misclassification. That seems to be the crux of those that are opposed to this. Look on page 2, line 16. Contributions by a hiring party to any portable benefit account shall not be treated as evidence that a worker is an employee of the hiring party, period. This does not change whether or not an employer is misclassifying an independent contractor. If that's a problem, then fix that problem. Don't use my bill here as an excuse to try to fix something else that you've got a problem with, because that's what this looks like. As evidenced by the example after example of 30 drywallers being used on a job who obviously weren't classified correctly. Well, that problem's still going to exist regardless of this bill. This bill is good as is. It's not just for gig employees. I specifically said this is not a gig employee bill. I use them as an example, just like we have other contractors out there. It should be available to all of them because it's good policy. This allows individuals who are working out there to have money contributed by the hiring company if they choose to help them provide benefits so that the state doesn't have to pick up those at some other point. This is good legislation. Mr. Chairman, I'd answer any questions if you have any and would encourage your support on it. Thank you, Chairman.
Thank you, Representative Bunks. And I apologize for not catching the pending legislation. New chair.
It was.
Representative Harris.
Yeah, I just would like to clarify a statement that I think this is great legislation. If I had the bill number in front of me, I'd make the motion, but I already closed my computer, so I'll leave that to somebody else.
Representative Palmer.
I move to send 645 to the floor with a due pass recommendation. I don't think I need to clarify everything that he just said because I agreed with it.
Yep. Committee, we do have a motion to send House Bill 645 to the floor with a due pass recommendation. Any further discussion? Representative Birch.
Thank you, Mr. Chairman. I'm not going to support the motion at this time, but I do reserve the right to, reconsider this on the House floor. The reason is I just want to further understand what some of the impacts are that may not be self-evident and so forth, and and what the consequences might be. I've heard some things in testimony here that I think are of some concern, and whether they're unintended or unintended consequences, I think it's important to understand that. So for right now, I just need to know more before I can support that motion.
Thank you, Representative. Committee, we do have a motion properly before us to send House Bill 645 to the floor with the due pass recommendation. All those in favor, signify by saying aye. Aye. Any opposed? Would you like to be recorded? Okay. All right. Thank you, committee, for all your hard work today. At the risk of losing committee members, we do have a busy day Wednesday and Friday as well. So I hope everyone will show up. Yeah. Seems like Representative Crane is coming down with something. Committee, we are on the floor tomorrow at 11 a.m. And with that, we are adjourned.
I think it puts a stake in the ground that says we have a sovereign right to protect what's ours.